In spite of getting so many decrees, they file miscases, and thereby since 19 years, I am out of possession of my land.
Now tell me, what is your prayer?
My prayer is that my Kali will listed for hearing on Tuesday.
Next Tuesday?
Yes, file.
Question on 24th. 24th.
24.
Yeah.
I have a similar prayer, my lord, hearing for listing my lord around 24th, my lord. The
20?
matter of 2014 matter.
22?
24,
24?
6.
On 26th.
This month, 24.
On 26th.
24,
Okay, on 26th, is it okay?
26. Must have been.
Please,
Yeah.
Lordship. In item number 7, Lordship, additional affidavit, 2 pages, the additional affidavit was filed, my lord, on 10th, Lordship. It may be directed to be tagged with the record, Lordship. Some, my lord, 2-3 pages additional affidavit, Lordship.
It has to be called for?
My lord, it may be, my lord, directed by sleep, Lordship.
Which item?
Item number 7, Lordship.
Okay.
Oblige, Lordship.
My lord, I am sorry, my lord, the item number 2, my lord, otherwise, my lord, the other side advocate also ready, but he given a message, my lord, in some medical urgency. He has gone to hospital for his, my lord, treatment of his recurrent one, his family member, my lord. So he requested me to fix the matter at 2, my lord. So this matter will fix
Today
today, my lord.
at 2 p.m.
At 2. It is a part of matter, my lord.
No, at 2 p.m. we have one matter of Arunachal Pradesh.
Before that,
Uh,
it is a small matter.
Maybe after that Arunachal matter,
concept.
only.
Bas,
Immediately after that matter.
bas.
Maybe. Well, this is a civil revision, Lord. So it may come on tomorrow or Monday, my lord.
Monday.
Monday.
Okay, Monday.
My lord, I am praying for listing on Monday. One second appeal, my lord, it was amended cost title has been filed. It has not been listed on Monday. And another for orders, my lord, 2017 matter. In spite of hearing, fixing date of hearing, it has not come in the hearing list.
Why?
Because some miscase has been filed by the other side. So may I pray on Monday for orders?
No, can it be on Wednesday?
Wednesday,
Because Monday it will be
It will come for orders. my lord.
maybe.
On
On 18th.
Wednesday.
Even then we have to pass the order.
Yes.
We have to hear you.
Much of.
May I please, the Lordship? Lordship, I pray for listing of a civil revision petition next week, Lordship.
Take it that from him.
Deeply.
On 2020.
My lord, I beg to mention item number 24, my lord.
24.
Yes, my lord.
Yes.
My lord, I am appearing for the respondent number 3 and 4, my lord. I have taken the consent from
When?
after 2 weeks, my lord.
After 2 weeks. Mr. Gupta, learned counsel for the respondent number 3 and 4 with consent from the other side, press for listing the matter after 2 weeks. Parallel.
Oblige, my lord. My lord, I have one another prayer. I pray for listing of one RSA for withdrawal, my lord.
When?
My lord, the parties have settled the matter, my lord. And
When do you want?
tomorrow or on Monday, withdrawal.
Tomorrow or withdraw?
Okay.
Tomorrow.
Tomorrow. And my lord, one civil revision petition, my lord, for motion, my lord. On Monday, my lord, it was moved.
Monday not possible.
Monday, so many.
Wednesday.
Oblige.
Yes.
Please, your lordship, with due consent from other side, I beg to mention item number 25 of today's list, your lordship. We are the appellant in this case. I pray that your lordship, this matter may be taken up after vacation, your lordship.
Why?
Lordship, counsel representing the case is not well, your lordship.
Okay. Ms. P. Portaker, learned counsel for the appellant with consent from the other side, press for listing the matter after
Vacation, your lordship.
Summer vacation.
26.
Lordship, after vacation.
Vacation.
After summer.
Okay.
Okay.
May it please, your lord. Lordship, I beg to mention an item for listing, my lord. ERPIO, my lord.
When?
My lord, tomorrow, my lord, there is some urgency. The trial court is fixed on 16th. Tomorrow, my lord.
One can.
Oblige, my lord.
May I please, Lord. I beg to mention item 21, Lordship. with the-
Item?
21. With the
Yes.
consent of other side, I may be allowed 2 weeks time for
2 months.
2 weeks.
2 weeks. Mr. Your good name, please.
S.H. Sharma.
Lordship, I am for a respondent in this case. Kindly one date may be fixed.
Okay. As agreed by learned advocates of both the parties, recess will list the matter on okay. After vacation?
After vacation. On 15th July. 15th.
In July. Yes, Mr. Sharma.
Lordship, I beg to mention item number 18, Lordship, with a consent to the other side. Lordship, my senior Ms. R.D. Majumdar is out of station, Lordship.
So next week, Tuesday, Lordship, if possible.
Mr. S.P. Sharma, learned counsel appearing on behalf of Ms. R.D. Mazumdar, learned conducting counsel for the respondent number 1 with consent from the other side. Mr. Talukdar,
Yes,
any objection?
my lord, since some difficulties arose, I cannot object. Last 2 times also I have taken.
When do you want?
Next Tuesday, my lord.
Next Tuesday.
Thursday, on Thursday.
Thursday, difficulties.
Already we have so many cases on Tuesday.
Tuesday.
There's a hearing, then on 24th. 24th.
Lordship, I have another Lordship. I beg to mention for listing of an IA Lordship. Actually, Lordship, here execution case has been initiated. So the
When do you want?
tomorrow or on Monday, possible.
Monday?
For
may not be
orders,
possible.
On Tuesday? Tuesday?
Obliged.
May I please, your Lordship? I praying for listing of an RSA in the stage of hearing on Thursday, next Thursday. And
Yes.
Please, your Lordship. Lordship, I beg to mention for listing of an IA. Next week, any date, Lordship.
Take it.
On 18th. Item for withdrawal. Item number 27.
May it please your Lordship. In this case, Lordship, I have information the original suit was dismissed on withdrawal, Lordship. And I had checked from online, it was disposed of on withdrawal on 19/12/2024.
Okay, Ms. R. Chaudhary, learned counsel for the petitioner submits that she has the instruction to withdraw this application. Accordingly, this taking note of the submission of Ms. Chaudhary, learned counsel for the petitioner, this CRPIO stands a disposal on withdrawal.
Lordship, I'm highly obliged.
Item for motion, bail application. Item 1.
May I please, your Lordship. Lordship, for a TT bail application, Lordship. This is Lordship, third time bail application, Lordship. Accused is behind the bar, Lordship, since last 4 years, Lordship. And Lordship, out of 9 prosecution witnesses, Lordship, only 2 witnesses has been examined, Lordship, till date, Lordship. And I have verified the case status, Lordship, through e-court service, Lordship. The case is fixed for production from last 11/11/2024, Lordship. And earlier, this honorable court, second petition, bail petition was rejected on Lordship 26/9/2024, Lordship. Therefore, Lordship, case is pending before the learned trial court, Lordship, from last 11/11/2024 to till date, Lordship, only for production of the accused persons, Lordship. I have verified it through e-court service, Lordship. And Lordship, other 2 accused, co-accused, Lordship, 2 co-accused already granted bail, Lordship. And Lordship, on last 8/5/2023, Lordship, coordinate bench of this honorable court has granted bail to the accused Gautam Rai, Lordship. That has also been annexed, Lordship. In this case, charge has been framed, Lordship, on last 23/12/2021, Lordship. From 23 to.
Let the record come. Heard, Mr.
T. Thakuria, Lordship.
T. Thakuria, learned counsel for the accused, and also heard
P. Upadhyay, Your Lordship.
you are standing counsel for NCB.
Your Lordship, appearing on behalf of SC Kyalson. He's the.
Where is Mr. Kyle?
Your Lordship, he's in Lex.
Where?
Your Lordship, currently in court 17, Your Lordship.
But can you appear on his behalf? How? Alright. You tell Mr. Kyle that this practice is deprecated by this court. This application under section 483 of the BNSS 2023 is prepared by accused Sahib Sani, who has been languishing in jail in connection with NDPS case number 29 of 2021. in NCT crime number 12 of 2021 under section 8C stroke 20B Roman 2 within bracket small c and 29 of the NDPS Act 1985 since 18/6/2021. Mr. Thakuria, learned counsel for the accused, submits that this is second bail application,
Third bail application.
third bail application. And the earlier two bail application being BA number 2311 stroke 2024 and the first one
Lordship, last rejection order I have mentioned, Lordship, that is, Lordship, last rejected on 26/9/2024, White PA number 2311/2024.
in which paragraph of your petition you have mentioned it.
In paragraph number, Lordship, 15, Lordship. Page 8, Lordship.
And the first one being BA number
2311/2000.
of 2024 was no, that order is you have enclosed here 26/9/2024 the first application when
Lordship,
it was dismissed.
this is second bail application, Lordship, 23,
This is
11.
second. But you have submitted that it is third bail application.
Yes, Lordship. Earlier one bail application was rejected on 2022,
The
Lordship.
first one
22, Lordship, on
22
2022.
where you have mentioned it.
Lordship, that has not been actually, Lordship, that matter has been conducted by some other councils, Lordship. That's why, Lordship, I could not get the number.
The second bail application. No. But the second bail application was dismissed by this court by the order dated 26/9/2024 in EA number 2311 of 2024. Whereas having heard the submission of Mr. Thakuria, learned counsel for the accused, it is provided that there is a call for the scanned copy of the record from the court of where it is pending.
Lordship, as additional session judge, Kamrup Rongya, Lordship.
From the court of learned additional session judge Kamrup Ramya,
Rongya, Lordship.
fixing the matter on
23rd June.
23rd June.
Must oblige, Lordship.
Item for admission, item 3, Parthad matter.
May I please, your Lordship, my lord, here in this case, petitioner is paying for pensionary benefits, my lord, for by counting his past service, my lord, and this honorable court already allowed their prayer, my lord, at page 52, your Lordship. On last occasion, my lord, understand sought time for some instruction, my lord.
My lord, yes, my lord, instruction was sought for, but the instruction from elementary education is not coming, my lord. And moreover, my lord, in the course list, although elementary education is party, but in the course list, it is not reflected that the elementary education is there. So, my lord,
My lord, for this reason, this matter is, and they will take the dates of the date, my lord.
So from secondary education, you have received the instruction.
secondary, I have received the instruction on earlier occasion, my lord, and accordingly, as per my instruction, Director of Secondary Education asked the Director of Elementary Education regarding the queries of the Finance Department, whether the past service can be counted for the pensionary benefits. So I have produced the letter on last occasion, that is 27/5/2024. Here it is stated, Education Department is requested to clarify while issuing order dated 30/11/2019, allowing counting of past service of the petitioner towards pensionary benefits as per Assam Service Pension Rules 1969, did the take concurrence of finance? If not, then why they are coming now to finance department now?
My lord, may I produce another letter, my lord? I have already annexed, my lord, page 69. That is letter dated 19/12/2020, my lord. In this letter, my lord, issued by the Director Secondary Education, my lord, at page 69, your lordship may found.
Yes.
Inviting reference to the subject quoted above, that is letter to the government, my lord, itself, Commissioner and Secretary of the Secondary Department. I have been honored to following the connection in opening of PPI on Sri Komrul Islam, assistant teacher, Dolu Higher Secondary School, Dolu under. Komrul Islam to the assistant teacher, Dolu Higher Secondary School, Dolu under Kachar district was allowed to count his first service for pensionary benefits only as per Assam Services Pension Rule by the Director Elementary Education by letter dated such and such 30/11/2019 pursuant to the government letter number such and such 2/11/2019 letter number such and such 4418 in compliance of the Honorable Court's order dated 14/12/2015 passed in WPC number 2284 of 2013 filed by Sharifuddin and 19 others. That is one of petitioner, one of the person. Accordingly, the said Komrul Islam Chaudhary, assistant teacher of Dolu Higher Secondary School under Kachar, now applied for opening of GPA account on the strength of the order dated Director Elementary Education Assam dated 30/11/19. In this context, it may be mentioned here that it is also mentioned that, here that the CPF education has been made since joining of the Sunapur Public School, Sunapur Kachar in respect of Komrul Islam Chaudhary, assistant teacher under NPS account bearing number such and such under Kachar Kachar. Under the above circumstances, government is requested to kindly issue necessary instruction whether TPF account can be allotted to Komrul Islam Chaudhary, assistant teacher, Dolu Higher Secondary School, Dolu Kachar, in order to allowing pensionary benefits since CPF deduction has also been made by Komrul Islam Chaudhary, assistant teacher, from his date of joining at Sunapur Public ME School prior to order issued by Director Elementary Education issued by the such and such date 21/2/2013, my lord. Thereafter, petitioner has already retired from the service in the year 2023, my lord. He has not been receiving his pensionary benefits, my lord. Since this honorable court already allowed their prayer, my lord. In pursuance to the honorable court order, the Director of Secondary Education issued this letter, my lord. And I have also annexed this order of this honorable court, my lord, relating to, because they are the drop teachers, my lord. Initially, their services were not regularized when their schools were, respective schools were regularized.
Where is the order of the court?
Order of the court is page 52, my lord, type copy, my lord.
Page
And
number?
event is page 55. It starts from 52, my lord.
Page?
Page 52, 52. And relevant is page 54, your lordship may found.
Where is the operative portion?
Operative 54, my lord. 54.
No.
For the
Operative
aforesaid
portion of
reasons,
the order.
your lordship got it.
Operative portion of the order.
Or page 54, my lord. 54. Type copy that is made.
Okay.
For the aforesaid reasons, considering the entire aspect of the matter, state respondents are directed to not to insist upon the undertaking from the petitioners as contained in their respective impugn appointment and regulation order dated 21/2/2013, issued by the Director Elementary Education Assam pursuant to the order dated order of the state government concurred by the Finance Department of the state with regard to the acceptance of new pension rules with that come into effect from state 1/2/2005 and give them the petitioners the benefit of past service for the pursuance of pensionary benefits as per Assam Services Pension Rules 1969 in terms of the direction contained in the said Jivan Chandra Teka's case Supra. However, the order of prayer made by the petitioners are not enabled since such directions are not given by the court in judgment and order dated on Jivan Chandra Teka on the basis of which petition service as prop teacher have been regularized with the prospective effect and accordingly other prayer of the period. That other prayer means, my lord, the arrear salary, my lord. In respect of arrear salary for that period, my lord. That was rejected. But so far as pensionary benefits are concerned, my lord, that was granted by this honorable court. Accordingly, the file were processed, my lord, and subsequently petitioner is retired from the service, my lord. Now petitioner is paying for his pensionary benefit, my lord, under Assam Services Pension Rule of 1969, my lord.
Anybody from Elementary Education Department?
Here, no one is there, my lord.
Can you inform him?
I can call my lord
We'll take the matter after some time.
after Sunday.
At two, my lord, it will be-
Two,
because they will also.
no, I have some problem, my lord, at two.
Okay.
Call him.
Damn it.
Item 4, hearing under order 41, rule to CPC, item number 28.
May I please, your lordship? My lord, here in this case, substantial question of law, kindly see page 6, my lord. Page 6, 3 and C and D. My lord, these two substantial question of law, my lord, I have typed in better way, my lord. May I permit it? These two substantial question of law, I'll show from the plaint itself. And so far is, one is concerned, my lord. The substantial question first. To that aspect, my lord, I am relying on Supreme Court judgment also, 2003 2 SCC. Regarding order 7, rule 3, my lord.
What is that judgment?
My lord, paragraph number 14 may kindly be. It was, my lord. Order 7, rule 3. Where the subject matter of the suit is immovable property, where the subject matter of the suit is immovable property, the plain shall contain the description of property sufficient to identify it. And in case such property can be identified by boundaries or numbers in record of settlement or.
You were reading paragraph number?
No, this is, I am reading order 7, rule 3.
Okay,
And that is paragraph number 14, my lord.
Okay.
Paragraph 14. Now kindly see, lordship, page number 9 of memo of appeal, whether they have complied this or not, my lord. Para 9, page 9, paragraph 4 of the plaint. Yesterday also I have read, the main defendant without any right, title, interest and possession over the scheduled land. After hearing that the schedule sold to the plaintiff, the main defendant taking advantage of the plaintiff as well as their vendor are residing at a distant place with ill motive and design encroach in some portion of the suit land. Some portion of the suit land by demolishing the boundary fencing and constructed temporary shed thereon on and about so and so, and as such plaintiff approached the pro forma defendant to cause survey and demarcated the boundary of the suit land. So they are not aware that how much land I have been dispossessed. And in the schedule, they have what they have been explained, no explanation in the schedule which portion I have been dispossessed. So better particulars they have not given in this plaint, my lord. So under such circumstances, order 7, rule 3, my lord. It is a mandatory that they should, description should be given in case of immovable property for recovery of possession, if there was a dispossession is there, my lord. This is one aspect. Another aspect, my lord, regarding 154 of the Assam Land Revenue Regulation. There is clear bar, my lord, in the prayer, kindly see first. Page 10, my lord, prayer. To that aspect also, I will show one judgment of our High Court, my lord. Prayer is, main prayer is for partition.
Section
154 of Assam Land and Revenue Regulation. main prayer is demarcation of the boundary. And after demarcation, my lord, precept be issued, then the recovery. So consequential prayer is the recovery after demarcation. Kindly see page 10, my lord, prayer. For decree of right title interest of the plaintiff over scheduled land, and for decree of delivery of first possession of the scheduled land to the plaintiff by demolishing the structure, construction, and removing the belongings of the main defendants therefrom by demarcating the boundary. So here in this case, both the court below has not appointed any commissioner. On what basis they come to conclusion that entire suit schedule has been encroached by us? There is no finding also. And their prayer is also not that entire suit schedule we have encroached. We have encroached, their claim is that we have encroached part of the suit schedule land. Which part? For that, the commission is required, my lord. But both the court below has not appointed, and their specific there is the precept be issued to the revenue authority to correct the revenue record. This prayer is also barred under section 154. Because mutation, they sought for mutation. Kindly see section 154 of Assam Land Revenue Regulation. Both the prayer, they are barred under section 154. Good.
Yes.
154. Matter exempted from cognizance of civil court. Lordship got it. So the claim number E, kindly see claim of person of imperfect partition. Here they are sought for demarcation by way of partition. And regarding mutation also there is bar. To that aspect, my lord, I want to show one
Regarding
judgment.
mutation, where is the bar?
My lord,
Regarding mutation. where is
mutation
the
also bar, my lord. They are, I'm showing, my lord. F, the description of the land allotted or revenue on, not F, it is B. Question as to the amount of revenue tax, says and rate to be assessed and the mode of principle of assessment. Mutation is nothing but an assessment of the taxes, my lord. So in view of the above, my lord, it may be admitted with these two following substantial question of law, my lord.
We'll again examine the matter.
My lord, I
We will reserve the order today. Heard Mr. S.K. Kus, learned counsel for the appellant. Order reserved.
My lord, I have filed one IA also.
On the day of passing the order, we'll
Yes.
consider your eye.
Yes. Only tomorrow is the date for execution.
Tomorrow?
Tomorrow. Much okay.
Standing item 3.
Mr. Sharma,
Lordship,
so you are a party in this proceeding, huh?
here perhaps the director is not the party here.
Pardon?
Director of Elementary Education is not the party,
Director is not a party,
not a party.
but DEO is there.
CEO is the party, Lordship. And perhaps our name is not shown in the cause list also. As a result, we missed the only secondary is stated, Lord.
Yes, respondent number 5 and 7. There District and block elementary education.
Lordship,
officer.
they are from the elementary education department also.
So director is not allied as a party.
No, my lord. Since my lord, he has retired from the Dolu Higher Secondary School, my lord. That's why I have not made them party, my lord. If your lordship direct me, I will make them a party. Otherwise, my lord, elementary education, district elementary education officer and block elementary education, they will represent my lord.
But now the information has to come from
Come
the
from the
elementary
director.
education department.
Hmm?
You write them as party here. In the meantime, Mr. Sharma, you obtain.
I will obtain
inspector
inspector.
list. Third, Mr. I Alam, learned counsel for the petitioner, and Mr. U Sharma, learned standing counsel for the respondent in the secondary education department. Mr. Sharma submits that the director of secondary education has already written a letter to the finance department for their concurrence. However, the finance department, by its letter dated 27/5/2024, has written to the director of elementary education regarding taking of concurrence from the finance department. For counting past service of the petitioner towards pensionary benefit as per the Assam Service Pension Rule 1969. And the said information is not yet been received. And further, Mr. U Sharma, learned standing counsel for the secondary education department, submits that the district elementary education officer, Kasar Silsor, and the block elementary education officer, Kasar Silsor, have been allied as a party. But the name of the
Director elementary.
but the director has not been allied as a party in this proceeding. And in order to dispose of this petition, the director is required to be allied as a party. Allied as a party in this proceeding. Further, taking note of the submission of learned counsel. For both the parties, it is provided that the director, secondary education Assam, the implicated respondent number 8 herein.
Director of elementary education. also.
Director elementary education, be allied as a respondent number 8 in this rate proceeding. Issue notice to the newly implicated respondent. Number 8. However, no formal notice is required to be issued since Mr. E. N. Sharma, learned standing counsel for the newly implicated respondent, entered appearance and received notice. However, it's the requisite copy of the petition be furnished to him of the day. Further, in respect of the letter of the finance department dated 30/11/2019, Mr. E. N. Sharma, learned standing counsel for the elementary education department, shall obtain assistant inspector and apprise this court on next day. After
Next
1
week. Next week, Lord.
next week.
On 23rd June.
23rd June. In the meantime, Mr. Alam, learned counsel for the petitioner, shall file his amended cost statement.
Well, it may be part of my lord.
Yes, recessal keep the matter started.
Item 4.
May it please your lordship. Lordship, as per office note dated 9/6/25, respondent number 3 was duly served and respondent number 4 notice was received by his wife and 1 and 2 has entered appearance. LCR has also been received, lordship.
So service completed.
Complete LCR has been.
Pardon, Ms. N. Saikia, learned counsel for the appellant, and Mr.
Yehu Ahmed on behalf of K. Bhattacharya, respondent number 1 and 2.
Learned counsel appearing on behalf of respondent number 1 and
2.
1 and 2. Ms. Saikia, learned counsel for the appellant, submits that as per office note dated 9/6/2025. Service upon respondent number 3.
Tuesday.
and 4 completed, and the LCR has also been received. And the matter is ready for hearing, and as such, it is prayed for listing the matter for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, it's provided that SSL list the matter for hearing. In usual.
Lordship, a date may be fixed, 122 July.
No.
Item 5.
Lordship,
Rest they will fix that.
Lordship may kindly pass over the matter for time being. Lordship, advocate for the respondent is on list at number 4.
Oh,
Chakrabarti.
please, Chakravarti.
Lordship.
I'm for the appellant. Let me start. So in the meantime, he will come. Like both.
Matter is ready for hearing.
And what has happened in this case, it's a injunction appeal. Mother has, I'm sorry, the daughter has filed a suit against mother. And an injunction was granted preventing mother from making construction over a plot of land, a part of which was purchased by mother herself, and a part was initially purchased by father, but then after the death of other legal heirs have sold their share to mother. But this particular plaintiff, although took some money and made an oral agreement to sell, but she ultimately did not sell her part. Now she is praying for injunction on the entire plot of land, and injunction has been granted, and that too after first floor, ground floor, first floor was constructed. After that, injunction has been granted, preventing her from making further construction. Well, considering the fact that the suit is between the mother and daughter, well, both the parties we requested the Honorable Court, this Honorable Court has directed for a mediation. Both the parties came there from Barakberi. Both the parties came and mediation was held in the complex, High Court complex in Guwahati itself.
What is the outcome?
Outcome, I think it has paid. Both are equal. Now the matter has to be taken up finally, but one part is there. So far as her share is concerned, mother's share is concerned, over that plot of land, there cannot be any question of any injunction, but the trial court has granted injunction on the entire land. Admittedly, one part is Schedule 1 was purchased by the mother herself. That is her property, her land. So a very small matter, my lord, if Lord takes up this and then.
But it has been listed in the order column today.
Because it has come with a report also.
I am appealing for respondent number.
Okay.
Pilot one, I'm subject to what my learned print says. One shortcut may be, admittedly, the trial court did not consider that Schedule A or Schedule 1 land belongs to mother. So there could not be any question of granting injunction on that. So that part has not been considered. If my learned friend agrees, I do not know. Matter can be sent back so that and
My lord, here, my lord, subject to my understanding, what has happened, there is a suit filed by respondent number 1 as plaintiff for declaration of her 1/6 share over an Ajmali property. Now, there are 3 principal respondents who are the appellants hearing who have come against the order of injunction. In the suit, my lord, there are 2 other sisters who are pro forma defendants, one of whom, after receiving notice in the suit, have come up in the suit and filed written statement along with counterclaim, wherein she has fought for partition of the suit property. I have a copy of the,
Okay, that's all right. Mr. Mazumdar has submitted one thing.
my lord.
Yeah. Are you agreeable? Say.
My lord, I am not aware about the proposition, my
My
lord.
lord,
Just he has.
I'm just repeating, my lord.
My lord.
Admittedly, Schedule 1 property was purchased in the name of mother.
Hmm.
Plaintiff herself is saying. So in view of, my lord, the provisions of the Benami Transaction Act, it belongs to her only. Nobody else can say that it belongs to some other person. So Schedule 1 was purchased by mother herself. So there cannot be any injunction on Schedule 1 also. But if your lordship looks at the injunction order, the injunction has been granted in respect of the Schedule 1, Schedule 2 both. So to that extent, my lord, the order is not correct. So what I was suggesting, my lord, basically, to be very, my lord, frank and fair, it's a dispute between mother and daughter. I do not want that the matter should remain pending here and the litigation should continue. So let the matter go back there. If necessary, they will sit once again for a
So here, my
amicable
lord,
solution of
my
the
lord,
matter.
responding to my senior colleague's proposition here. Now, yes, apparently, so far Schedule 1 property is concerned, that is in the name of the mother. So far Schedule 2 property is concerned, that was purchased by father. But the problem is, my lord, there is a house standing upon the suit land which covers the portion of both the schedules. And now there is, my lord, one aspect, another aspect of the matter. This matter, if your lordship perhaps has, my lord, taken note of, was also placed before the mediation of our honorable High Court.
Mediation failed.
Yes, it failed, but the reason why it failed was, my lord, it is, my lord, given to understand that 1/6 share of the plaintiff, who is the respondent number here, that has already been asserted. Now, that portion is there within the, my lord, suit property, but there is no pathway. There is no, my lord, possibility of ingress and outgress, and that ingress and outgress, if it is to be taken out, it has to be taken out from the Schedule 1 property, which happens to be of the mother, admittedly. Now, that was the proposition which was placed before the mother during the mediation, that is she agreeable to spare a pathway? My learned junior friend was there, he will perhaps concede to that. Now, that was the point of disagreement, where the mother said that she is not going to spare an inch. Now, if there is no pathway to go in and come out of the 1/6 share that has been allotted, and I'm happy with that 1/6 share. But my lord, that 1/6 share cannot be, my lord, exceeded by way of helicopter. That has to be gone into either by walking or by normal means of, my lord, accessing. Now, that was one aspect which, because of which the settlement failed. Now, my lord, insofar as the suit is concerned, in the suit, my prayer for injunction was to the extent of restraining the defendants from carrying out construction over the suit property, which embarks upon both the schedules. It is not that construction is only getting carried out on the property of the mother. And my lord, in the impugn order, the learned court below, in my respectful submission, has rightly, my lord, arrived at a conclusion that insofar as the entitlement of the daughter to the 1/6 share is concerned, there being a house standing thereupon which covers or which embarks upon a portion of both the schedules. Now, that aspect needs further consideration by way of leading of evidence. Now, till the suit is adjudicated, if a status quo has been directed to both the parties, my lord, in my respectful submission, my lord, this perhaps is not an order. And it is only till the adjudication of the suit. It is not a perpetual permanent injunction. It is till the adjudication of the suit by way of leading of evidence
So,
that
admittedly, Schedule 1 land is in the name
the
of
mother, mother,
Then how can the injunction can be granted?
the house that has been constructed during the lifetime of our father, that was constructed by our father, which embarks upon the portion of both the land. Now, to this, my lord, my senior colleague will have objection. Now, if this is a point of dispute, this requires adjudication. I am saying that there is a house which embarks upon both the schedules. Schedule 2, which is of my father, Ajmali property. Schedule 1, my mother's property, exclusive property till she is alive and until she has done away with it to anyone else. Now, insofar as doing away with that property also, my lord, there is a dispute. She says that the shares of the Schedule 2 property of the co-sharers have been vested upon her by way of a sale deed in which there are signatures of all the daughters. In the impugn order, my lord, there is a categorical finding that, my lord, signatures were obtained on blank paper. So there are so many aspects which are, my lord, required to be adjudicated in the suit. So that's why till the adjudication of the suit, the fact remains that they are constructing, they are raising construction over the portion, over the land which is not exclusively the Schedule 1 land. We have categorically stated that the house overstanding upon the suit lands embark upon both Schedule 1 and Schedule 2, which was constructed.
Mr. Mazumdar, why a part cannot be spared to her?
Yeah,
My lord, it is because of this that, my lord, we both the parties agreed that they should sit together and finalize, but somehow it has not taken place. But I'm aware of what is the dispute. My lord, I'm very my lord, thankful to my learned friend that he has at least disclosed before this on the court that the real dispute between the parties is the path. Now, if for not being able to get the path cleared in order to go to her share of land, she has obtained an injunction to restrain me from making further construction. Her prayer should have been that kindly grant a temporary mandatory injunction allowing me to go into my own land. Instead of praying for that, she has chosen a different way that I will prevent mother from making further construction. There is a photograph lying in the case record, Lordship will see. The construction has come up and there was, we understand that housewarming, after the construction, first ground floor and first floor was constructed, a housewarming was arranged where she has attended. She did not have any objection, but and she has taken 2 lakhs for selling her share of land also to mother.
All disputed.
Disputed, but then it is pleaded case of the defendant, my lord. And after that, she is asking, now saying that no, I will not sell. Because her nature and my client's nature, my lord, both my learned friend has seen, I have not seen in the before the mediation.
Fortunately, my lord,
So now
we are-
at this stage, my lord, the sadistic pleasure the plaintiff is getting is, since I am not able to go to my land for being prevented from entering through the pathway, I will restrain them from making further construction. My lord, is it the law that since you are not able to get, because her prayer should have been that if she is saying that yes, my share is separated. If your share is separated, your only grievance is that the path should be made clear to you so that you can enter into your land. You pray for an injunction that I should be given. This honorable court may grant also. Instead of paying for that, what she is paying is that construction of the entire building should be stopped, and that has been granted. So this is nothing but getting a sadistic pleasure.
My lord, so far the
And with the help of the honorable court.
Mr. Mazumdar,
My lord.
this matter ought to have been settled outside the court.
Yes, yes,
This
and
is
that
a-
is why my lord, on the
mother
first
and
day,
daughter.
on the first day we agreed. I also agreed, my lord. In fact, I offered it that it should go to the mediation.
And Mr. Chakraborty, ultimately you will entitle the property after her demise.
My lord, the relation is such what I have seen. She
I
may
don't-
dispose it off before her
You
demise.
being the daughter, you will entitle
My
the
lord,
property.
the relationship is so sore that my apprehension is that before her demise, she will dispose of her property. And so far as the house standing on both the schedules, now, my lord, that house also, my lord, my only contention.
My lord, building has come up. Sons are residing there with their family members. There is no question of any sale to a third party.
My lord, that building, I have.
It's an admitted fact.
I have nothing to do with that building, but only thing your lordship will appreciate, if the building is also embarking upon some portion of the Schedule 2 property, which admittedly, my lord, is a Ajmali property. In that case, if the suit is not decided to the extent of determining my 1/6 share. Now, what, my lord, the 1/6 share that my senior colleague is saying that I have already been separated with. Now, that separation of share, my lord, is not something that has happened amicably. That is only, my lord, a negotiation. I would have been happy if I would have had a pathway to that 1/6 share. But so far, my entitlement to 1/6 share by means by meets and bounds, that can always happen. That can only happen by way of a partition. And insofar as this suit is concerned, just that I have pointed, my lord, a while back to your lordship, this suit also is parallelly going on for for consideration of the partition prayer that has been made by one of the sisters.
And she has sold her share in 1981. Today she is coming for partition. The other sister, which my learned friend is referring to, has now filed a counterclaim for partition. She has sold her share from which she has inherited from her father in 1981 by executing a registered sale deed.
Page number 45.
Admitted fact.
Page number 45. Blank signatures were obtained on blank papers.
Mr. Mazumdar,
My lord.
are you in a position to spare a thoroughfare through your land?
My lord, that prayer, my lord, is not there in the suit. Lordship will kindly see.
Maybe. You tell me, are you in a position?
And then if this kind of order is passed, my lord, it will be beyond the.
No. I will not pass any order.
My lord.
I am just asking you.
I'll have to ask my client.
Can we try to settle the issue?
Well, I was always thinking that it should be settled out of court. That is why it was sent to the mediation.
Is there any scope of any settlement if we call the parties to the court?
Inside the court, my lord.
Yes.
Because before the mediator, they have shown their my lord, conduct, and the mediator has ultimately said that it is failed. But possibly this second effort will be unnecessary because both the parties are arrogant. That is clear.
Adamant, perhaps.
Then you obtain instruction from your client that whether she is agreeable to spare a thoroughfare through her road, no, through her land to the respondent hearing.
To her land.
We will list the matter after 1 week.
This is only one aspect will remain. Our specific case is that in order to sell her share also to me, that is to the mother, she has already executed a oral agreement to sell and taken 2 lakhs rupees from mother.
These are disputed, my lord. These are things perhaps.
That is the specific case of the present appellant.
Which will come as an impediment for a settlement, because these are things which have been staunchly disputed so far. My taking of 2 lakhs, so far the other sister's signature, these are in the order itself. The impugn order at page 45
Certain
says.
facts have been pleaded by us that there was we call it in our vernacular language, ghar sanchar. And a huge ceremony takes place there. She comes, she participates, she raises no objection. A three-story building comes up. At this stage, she is now saying that I will not sell my share. I will not allow you to construct also. That is her attitude. That your lordship will consider. And now technically, my lord, injunction has been granted on the entire land, whereas Schedule 1 land admittedly belongs to mother. And I'll urge upon your lordship, my lord, so far as Schedule 1 is concerned, that part may be lordship may clear that there cannot be an injunction on Schedule 1 because admittedly that belongs to her.
But the only problem, my lord, the house is upon the portion of both Schedule 1 and Schedule 2, and that has been constructed by the father.
All right. Now, so far Schedule 1 is concerned, because no, in the plaintiff herself has given Schedule 1 property separately in Schedule 1, the part which was purchased by mother.
And then there's a counterclaim.
Lordship will say that Schedule 1, there can be injunction. Counterclaim will be decided after the end of trial. Today, your lordship is to consider on the basis of the pleadings made by the parties. So admittedly, Schedule 1 belongs to mother. Plaintiff cannot pray for an injunction on the basis of a counterclaim filed by one of the pro forma defendants. That cannot be a basis for making a claim by the plaintiff.
I'm not making claim on the basis of this counterclaim.
What
The thing I'm saying is that both the schedules have the house embarking on the portions of both the schedules. So if that be so, the only way out, even my lord, if my 1/6 share is decided also, even then I'll not be able to enjoy my share unless and until there is a partition by meets and bounds. It is a family property where it has been, my lord, so long the relation was sweet.
Lordship will see the photograph of the building, what kind of building has come up. And after this much construction was completed, now she is raising a dispute that no, I will not allow you to construct. This is the position. I think there's one more photograph where the area is there where they are claiming that there should be a path.
My lord,
For a path, they can always file an application seeking that kindly allow us to use the path. And there you will.
but this building is concerned, my lord, all the way along, I was under the impression that this is also a property to which I have shared. Now, if here also
Mother
there is
is
a
constructed.
dispute that I do not have shared, let it be adjudicated, my lord, in the suit. Or if there is a possibility of settlement by sparing a pathway to my 1/6 share,
My lord, I
I'm
should
happy,
not- I
I'm
should-
happy with that also.
My lord, I should not use words which appear to be rhetoric, but otherwise, there is no mother in this world who would like to deprive a daughter from her share.
No, world has changed.
And here is a case where the daughter is, I must say here, daughter is so violent, she fights physically. She has assaulted another sibling physically. That is the nature of the daughter.
My lord, I'll reserve my submissions in this regard. There are criminal cases pending who has filed against whom. I would not want to concede here. It is the daughters who have filed a criminal case upon the brothers who were, my lord, aided by the mother. So these are aspects which I'll not go into. But only thing, my lord, I am entitled to my father's property who died intestate. Now, if this is something that, my lord, I am seeking an adjudication upon because of dispute being raised, and there is an injunction till the adjudication of the suit, I don't find, my lord, anything wrong in this order. Yes, in between, if there is a possibility of settlement, my lord, I'll be happy. But for settlement, my lord, on the last occasion, what I personally witnessed, settlement failed because of mother's adamance to spare that path which would lead to my share.
But my last submission will be, so far as Schedule 1 is concerned, that your lordship will say there cannot be an injunction on Schedule 1. The rest, the parties will take care. Otherwise, this is the case.
Yes.
My lord, so far my contention is concerned, even in the impugn order, your lordship will see, it has been very categorically held that even in a portion of Schedule 1, my lord, there are constructions raised. If your lordship kindly takes up the impugn order for a while, here, if your lordship sees from page 44, my lord, there are appreciations of all these facts which have eventually resulted in the injunction order being passed. So today, in this, my lord, my humble contention in this appellate stage, can this factual aspect be decided without adjudication of the suit? It would almost amount to an issue of a pertinent issue of a suit being decided here in an appeal against an order of injunction. Order of injunction, my lord, that has been appealed against, my lord, only scope, my lord, that, my lord, subject to correction, the appellate forum, my lord, will exercise, this being the appellate forum here because of the suit value, would be whether there was the three cardinal principles of before granting injunction which was followed. Prima facie, I have a case because I am the daughter. I am entitled to 1/6 share over my father's property. So far as balance of convenience is concerned, the fact remains that the suit property, my lord, is yet to be partitioned. So from that point of view, also the balance of convenience is there. And irreparable loss and injury, my lord, will obviously I'll incur if before adjudication of the suit, they are allowed to raise construction and thereafter alienate. Obviously, there will be nothing remaining. There was a proposition on the last occasion before mediation that they would place me in a separate property similar to the 1/6 share value. I don't want that. I have emotions attached to my father's property. I am entitled to my father's property. And my lord, in a way saying that I'll give you 1/6 share, but I'll not give you pathway, indirectly means I'm not giving you the share also. Because a 1/6 share, which does not have ingress and egress, is of no value for me or for anyone for that matter.
My lord, admittedly, Schedule 1 belongs to mother. There is no dispute about that. And secondly, my lord, the injunction has been granted in respect of the entire land, both Schedule 1 and Schedule 2.
No, Mr. Mozumdar, you tell me the
Right.
order was passed after hearing both the parties.
Yes.
Whether you have pointed it out to the learned trial court that Schedule 1 belongs to you.
My lord, it is an admitted fact. Lordship, kindly see page 12. They have admitted in the plaint itself. The plaintiff has admitted that the Schedule 1 belongs to mother.
Where is the plaint?
Page
number?
12, my lord.
Page 12.
My lord, paragraph 3. They are only saying that father purchased in the name of that. After the Benami Transaction Act, there is no question of father purchasing in the name of mother. Paragraph 3, my lord, page 12. That the predecessor of the parties, Bhupendra Chandra Pal, sometime in 1981, when he was in service of Indian Army, had purchased the land described in Schedule 1 below with his own fund, but in the name of the principal defendant number 1, his wife. So, admitted position is Schedule 1 belongs to wife. Now, so far as Schedule 2 is concerned, yes, it will belong to father, but other legal heirs have sold their share in 1981 to mother. 81?
Page
To-
number 12,
to
paragraph
mother.
5, my lord.
Now, the trial
Paragraph
court
5 of page number 12, since your lordship is taking paragraph page number 12, paragraph 5. That upon the demise of
My lord,
Bhupendra Chandra
No,
Pal.
just a minute.
Mr. Chakraborty, let me.
Well, page 39, I'm just pointing out what your lordship has asked me, my lord. Page 39. Page 39, the real facts, we have mentioned all these things in the written objection. Page 39. Paragraph after the real facts, my lord, in my lord, bold letters. That while registered sale deed number so dated so 1981 of the Office of the Sub-Registrar of Southern Joint Silchar, principal defendant number 1 purchased the Schedule 1 land for valuable consideration out of her own savings and Sridhan from Abdul Quddus, Borbuya and others, and became the absolute owner of the and possessor thereof. That subsequently in the year 1984, the husband of the answering defendant purchased the Schedule 2 land from Musammat Nenu Begum, and Schedule 2 land is situated on the contiguous western side of the Schedule 1 land. That in due course, after the death of husband of answering defendant, Bhupendra Chandra Pal, who died leaving behind the answering defendant number 1 as his widow and the plaintiff and the principal defendant number 2 and 3, and pro forma defendant 4 and 5 as his sole legal heirs and successors. All the legal heirs and successors of the Bhupendra Chandra Pal affected mutual families arrangement among themselves and apportioned their respective shares over the Schedule 2 land of the plaintiff. Subsequently, principal defendant number 2, 3 and pro forma defendant 4 and 5 agreed to sell off their share of Schedule 2 land in favor of answering defendant number 1. And accordingly, principal defendant number principal defendant 2, 3 and pro forma defendant number 4 and 5 have executed registered sale deed number so of 16/2/2009, conveyed their entire share of Schedule 2 land of the plaintiff in favor of answering defendant number 1. It should be mentioned here that in the said registered deed, husband of pro forma defendant number 4 and 5 signed in the deed as witness. The plaintiff, however, started creating trouble in the matter of conveying her share of Schedule 2 land in favor of principal defendant number 1, although she received a sum of ₹2 lakhs only as earnest money from the principal defendant number 1, pursuant to the oral agreement by and between the answering defendant number 1 and the plaintiff. That it is pertinent to mention here that in the year 2008, the plaintiff for wrongful gain initiated a proceeding under Section 147 CRPC for enforcing her right over the imaginary Schedule 3 path, and managed to obtain an order to effect that the principal defendant 1 agreed to allow the plaintiff to use the imaginary Schedule 3 path. But such order dated so passed by the so SDM Kachar Silchar in case number so was challenged by the principal defendant 1 by filing revision petition by criminal revision number so and the revision session judge by judgment and order set aside the order so and allowed the revision petition. That while the answering defendant number 1 was in use and enjoyment of her purchased land within definite boundaries by mutating her name in the land revenue records and also by paying taxes to the government regularly, the plaintiff undertook construction of a building over her bona fide landed property after obtaining due permission from the Silchar Development Authority on 24/8/2012, and such construction was completed in the year 2015, and a Ghar Sanchar ceremony of such building was duly attended by the plaintiff and her husband. That having failed in her efforts to forcibly etch out the imaginary Schedule 2 tree path over the bona fide and exclusive Schedule 1 land of concern dependent number 1 to the medium of false and vexation, second 147 CRPC, the plaintiff has filed the instance. This is the position. Now, my lord, these being the position, and as we have heard from my learned friend, my lord, there is a specific share she has. Now, all right, there is a dispute and she is being prevented by mother for entering into her land through that path. The suit should have been for a suit for either easement right or for a right to enter into her land through that path and praying for an injunction that she should not be prevented. A mandatory injunction should have been prayed. Now, what course she has adopted is that I have got a land there, I want to be there, and you stop construction. And in the process, the learned trial court holds that balance of building has come up. Now, where is the question of balance of convenience in favor of the plaintiff? And on top of that, we are saying that you have accepted 2 lakhs rupees, you have attended the housewarming ceremony, you know that construction is coming up. Today, you are saying that no, I will not sell, I want to go to my land, I want a part. Construction has come up at a time when she has agreed that she will sell her part. Accordingly, construction was made on the land. Now, today she is saying that I will not sell her part, my part also. Then naturally a question will come from where she will go. You have agreed not to retain your part and to sell it to mother and take part of advance money also. Now, today, if suddenly you say, no, I will not sell it, now the question will come from where you will get your path. In that sense, my mother is right. Initially, you agreed, today you are saying that you will not sell. And the constructions come up. Now, today, we are preventing mother from making further construction. Mother is making not for herself, for her children. Her 2 sons are there, married sons are there, they are residing there. Her suit should have been a suit for at all if she doesn't want to sell her part and she says that no, I have got my land in schedule, her share will remain in schedule 2 at all, if any. Not in schedule 1. The trial court grants injunction over entire land of both schedule 1 and 2. So, if there is no agreement, well, my submission will be,
Your pair is this injunction order.
my lord.
So far, it relates to Schedule 1 land has to be modified.
Absolutely, my lord. Schedule
And
1,
matter has to be remanded to the trial court.
my lord.
That is your submission.
My lord.
Yes, Mr. Sapur.
Paragraph 4 of page number 12, my lord. What I am, my lord, trying to make, submit.
Paragraph number 5.
Paragraph number 4.
4, yes.
That subsequently said Bhupendra Chandra Pal sometime in 1984 also purchased the land described in Schedule 2 herein below in his own name and the contiguous west of the Schedule 1 land and kept the Schedule 3 pathway from within the Schedule 1 land for egress and ingress to and from Schedule 1 land as the said Schedule 2 land had no other pathway. Thereafter, he constructed an Assam-type house covering both Schedule 1 and Schedule 2 land where the plaintiffs were born and brought up till her marriage. This is my categorical pleadings, my lord. The construction that is being carried out, it embarks upon both Schedule 1 and Schedule 2 land. And my prayer, my lord, so far my prayer in the plaint is concerned. If your lordship kindly sees at paragraph number at page number 14, I have, my lord, prayed for a declaration of Ejmali right over all the 3 schedules. It's not that I am sparing Schedule 1 here, because on Schedule 1, there is a house that covers the portion of Schedule 1 and 2. And there was a pathway at the time of my father being alive, which now, my lord, is projected to be within the exclusive entitlement of my mother. Now, all these aspects, my lord, were taken into consideration. The other aspects, my lord, which have not yet been placed are that because of such construction carried out, there were complaints made before the development authority, who is the permission giving authority for construction. There is a specific order where the development authority, my lord, restrained the defendants from carrying out any further construction. Violating that order also, construction was being carried out. Therefore, the filing of the suit and the injunction petition with the prayer for stopping the construction. These things are very much in the impugn order, my lord. this aspect of there being a restraint order by the competent authority, your lordship will see page number 46. Page number 46 is the my lord, continuation of the impugn order. If your lordship, my lord, sees just fourth line from the top at page number 46 of the appeal.
Yes.
The averments of the petitioner also show that since February 2023, the principal defendants have started construction of a multi-storied building over the joint land of the parties without permission of the plaintiff or pro forma defendants. All leads to stop construction by petitioners were heard by the OPs, and thus being compelled, petitioner lodged a complaint to Silchar Development Authority Silchar on 13/2/2023. By order dated 18/4/2023, the Silchar Development Authority had directed the principal defendant number 1 to stop all construction works forthwith. But as per the petitioner plaintiff, the principal defendants have not stopped the construction work. Rather, they were carrying out the construction work in full swing, showing complete disregard to the Development Authority and also denying the Ajmali right and share of the plaintiff over the Schedule 1 and 2 land and houses and common uses of Schedule 3 pathway. And as such, it has become absolutely necessary to pass an order of temporary injunction as aforesaid, hence the prayer. So this is the factual position, my lord. Now, these are things which obviously will be disputed, and then these are things which have to be adjudicated. Now, whether there was any such order dated 18/4/2023, thereafter, whether this order has been assailed, these things are to be considered in the suit. Now, the only thing the learned court below has done is still the adjudication of the suit. An order of injunction has been passed. Now, they are, my lord, so desperate to get this order set aside, which also clearly indicates that they are, my lord, with the intention to cause irreparable loss and damage and injury to the plaintiff over here. Because here it is only a question of adjudication of these issues. Thereafter, the entitlement can be either mine or theirs. And I am not raising any construction. Construction is being carried out by them. If at all, if any loss is to be incurred, it has to be incurred by me. In case of the, my lord, suit being adjudicated in my favor, and if they are allowed to change the nature and feature of the suit land now, the injury will be upon me, not upon them. But if they are stopped from carrying out construction till the adjudication of the suit, they will not suffer any loss or injury. They have sufficient accommodation to reside over there. All the two brothers and mother, they are residing with sufficient accommodation. It's not a question of there being no accommodation for them to reside. And my lord, insofar as this taking of 2 lakhs and relinquishment of the entitlement, kindly page number 45 once, my lord. Page number 45, this is also one aspect that was taken note of. Down below, the last paragraph. Last paragraph of page number 45. One copy of the deed of memorandum dated 12/7/2008 is filed with the suit, which shows that the principal defendant number 1, mother of the petitioner, has admitted that she took blank signed papers from the pro forma defendants, who are the other sisters of the petitioner, and lost the same, but assured not to do any act against the interest of the pro forma defendants with those papers. Now, this is one aspect which is admitted as per our contention. There is one memorandum that we have cited. Now, connecting to this is the counterclaim by that sister whose signature was taken, and it was shown that she has relinquished her right by selling the her portion to the mother. But in the counterclaim, she is coming up with a prayer for partition. Now, all these aspects have to be adjudicated, my lord. This categorical finding, your lordship will kindly see this even in the impugn order. This aspect has been taken care of. This has been taken note of at page number 51. It is not about me and the appellants only. At page 51, my lord, kindly just for a while, page number 51. Last, the paragraph down below. Moreover, as the suit land has not been partitioned till date, and if the new multi-storied building is constructed covering Schedule 2 land, the valuable partition of land of the plaintiff and other co-sharers will be affected. Hence, balance of convenience is tilting in favor of the petitioner. Also, if the OPs are not restrained by an order of injunction, irreparable loss will be incurred by plaintiff petitioner, who claims to be the co-owners and have not given consonance to the opposite parties to construct over Schedule 2 land. So here also a finding is there that everyone will be affected in case of mallet construction being raised.
No, this observation was made in respect of Schedule 2 land.
Schedule 2 land.
Not in respect of Schedule 1 land.
Schedule, mallet, in so far Schedule 1 land is concerned, mallet, the observation is my lord, your lordship will kindly see, I had just read it out a while back and at page number 46. Regarding the stop construction, my lord, that is in relation to schedule 1 and 2
No,
land.
that is not the finding of the court. That is the narration of facts.
Yes, that is the narration of facts, but that covers schedule 1, 2, and 3, all the 3 schedules. And in the plaint also, my lord, that senior has said that I have only made prayer in regard to schedule 2 land and the pathway. But
No,
I have,
Mr. Chakraborty,
My lord.
you from the impugned order
my lord,
show me whether the court has recorded in finding,
my lord,
recorded its finding in respect of schedule 1 land.
my lord, I'll show that one.
Page 52,
Page
that
four-
finding is there. Page 52. In bold letters, trial court says at page 52.
Hmm.
In bold letters, what will it say? See in the middle.
Hmm.
The principal defendants, OPs, are restrained from anyway making or continuing with any sort of construction work or from changing the nature and feature of schedule 1 and 2. Schedule 1 and 2, how can you grant?
Because my prayer is there in the
Your
plaint.
prayer is there, but your pleading is that it was purchased by my mother.
No, paragraph 4, my lord, I am saying that house is there upon both schedule 1 and 2 land. Paragraph 4, I have just read it out. That cannot be ignored.
Well, one submission I will make, restraining the construction in the beginning is one thing. After it has their roof casting for 2-3 floors, my lord. Today, by preventing her from making construction in the 3rd floor or 2nd floor, how they can prevent changing the nature and character? In the beginning, if you come and say that I'll not allow any construction because it will change nature and character. Now, after 2-3 floors have come up, roof casting is over. Now you say that there will be change in the nature and character of the land. 2nd floor construction or 3rd floor construction will not help you in protecting your nature and character because constructions have only come up. Today you have come and your Silchar Development Authority passes an order in 2023. Construction started in 2015 and completed at that time. So development authority,
Okay,
how
okay.
passes?
Heard Mr. D. Mazumdar, learned senior counsel assisted by Mr. D. Mazumdar, learned counsel for the appeals. The appellant and Mr. T. Chakraborty, learned counsel for the respondent, argument concluded, order is
Obliged.
It must come to an end. It must come to an end.
My lord, much to the
Obliged.
end of our miseries, my lord. We are also embarrassed, my lord, fighting on behalf of mother and daughter. It is really embarrassing.
Unusual.
I
unusual
never,
precedent.
right, on the first day I indicated this on the court that there should be a mediation so that they settle the matter so that we are not blamed in future.
The filing of the case by the daughter against her mother is
Very unfortunate.
unfortunate.
They should sit and the relatives, all their elderly persons, well-wishers should sit and see that this litigation do not continue further.
Anyway,
My lord, my lord.
Obliged.
yes, next item.
Number 6.
Lordship, service is complete and LCR has also come, Lordship. Matter may come for hearing also.
Okay. Heard Mr. S.S. Soikia, learned counsel for the appellant. And Mr. K.U. Ahmed, learned counsel for the respondent number 1.
1 and 2.
And R.K. Das for respondent number 3. R.J. Das for respondent number 3. And Ms. P. Portakur for respondent number 4. It is submitted at the bar and when service upon all the respondents completed and LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that recess shall list the matter for hearing in usual course.
My lord, 29th of July, my lord.
Recess will fix the date. What about this IA, Mr. Soikia?
Lordship, additional evidence and appellate stage, Lordship. That may be heard at the time of hearing. Lord.
Okay, we will not pass any order today. You press at the
Yes.
time of hearing.
Yes, Lord. Obliged.
Item 7.
May I please, Lordship? Well, the IA is listed, my lord, that IA is for my lord, staying execution of decree, Lordship. The appeal has already been admitted, Lordship. The, my lord, the case, my lord, I am the defendant, Lordship, in the trial court part, my lord, the title suit was dismissed, Lordship, subsequently on appeal, Lordship. It was allowed, my lord. Decree is for declaration of declaring the right title interest and eviction of the petitioner from the my lord land lordship. Now I am in possession, my lord, unless the my lord execution is stayed, tomorrow is the date of my lord fixed before the executing court lordship. I have filed an additional affidavit lordship. In that case, the order is annexed lordship. Unless my lord it is a state lordship, the my lord applicant will suffer my lord irreparable loss. He will be evicted, my lord. His homestead is there lordship. His residential house is there lordship. So order is my kindly see my lord additional affidavit my lord annexure 6 page 85. Tomorrow is fixed lordship.
Lordship, before coming to that, we have not received the said
He appeared subsequently.
Along with that, we have received an additional affidavit. At the
No, it
same
was-
time, LCR will be called for also because LCR will be required for that.
Why?
Also, Lordship, I like to enter.
Why LCR is required?
Also, I like to enter the Lordship respondent number 2, as far as we know, we are for respondent 1, 3, and 4. So respondent 2 are died.
Where is
1 year
the
back.
additional affidavit?
By order date to 27/5, my lord, it was admitted lordship. And the IU was filed along with the appeal lordship memo.
Lordship, let us furnish the copy of the IA, Lordship. along with
I'll
it.
furnish, but notice was issued, my lord, it has gone to the my lord.
We are appealing for 1, 3, and 4.
Though it is a listed tomorrow,
Yes, lordship.
it is not for
It is an order copy, Lordship.
execution but for submission of some dates,
My lord,
up to date orders.
Yes,
my lord,
So you furnish a copy to
previous
him.
order,
Let us furnish the copy of.
well, I'll file my lord, till the, my lord, at least till tomorrow, my lord, it may be stayed lordship. Otherwise, my lord,
Lordship, without having the copy,
my lord, this is the my lord,
No,
second
no,
appeal,
no,
appeal has been admitted
No,
lordship.
Mr. Ahmed, let it be on next Monday, Tuesday.
Till then, my lord, some
No,
protection
no,
made.
no, no.
Otherwise, if it is my lord executed lordship.
No. There is no question of execution. You see the order. Submission of up to date order.
My lord, on the last occasion, appeal was admitted lordship. My
No,
lord,
that's all right. Appeal was admitted.
it was my only submission of up-to-date order, Lordship.
Opportunity has to be afforded to him also to respond to the
We are
IA
appealing
and
for only 3 and 4.
to the affidavit filed by you. Heard Mr. Ahmed, learned counsel for the applicant, and also heard Mr. Bakir, learned
1, 3, and 4.
counsel for the respondent opposite parties. This interlocutory application is referred by the applicant stroke appellant for staying operation of the impugned judgment and order dated 16/11/2024 and the decree dated 8/11/2024 in title appeal number 27 of 2020. The learned counsel for the respondent opposite party submits that he has not been furnished with a copy of this IA and also the additional affidavit filed by the
Additional affidavit we have received.
he have received.
Mm.
He has not been furnished with a copy of the interlocutory application. However, Mr. Ahmed, learned counsel for the applicant, undertakes to furnish a copy of the application to the learned counsel for the respondent during the course of the day. Place the matter on Tuesday.
well, as regards this order lordship, what I am submitting, lord, as regards this order lordship, some observation, my lord, just an observation may be given, my lord.
What observation?
My lord, the date is fixed for my lord, up to date
For
order.
execution of the decree, the court has to issue writ.
My lord,
It is not.
my lord,
Lordship,
that observation will, my lord.
Lordship, my humble prayer is let it be on Thursday, Lordship. Tuesday will be difficult for us, personal difficulty.
No,
Lordship.
Tuesday.
My lord, at least, my lord, as regards this.
No, on Tuesday we will consider
A
it.
line, my lord, I'm not for stay lordship, my lord, as regards observation that, my lord, tomorrow is fixed for my lord.
No, not necessary. Don't worry.
Number 8.
How like that?
Submission.
May it please your lordship. Lordship, in this matter, we had filed a title suit. Against that, the respondents had filed a counterclaim along with a injunction petition. And in that injunction petition, the court granted temporary injunction. Against that, we came in appeal, and thereafter, after the dismissal of the appeal, we have come in revision. So, your lordship, on an earlier date, this honorable court had granted a stay of the injunction order, and the respondents have appeared, so it may come up for hearing.
Lordship, before Lordship goes for fixing a date for hearing, Lordship, let me just come to this petition. They have filed before the trial court. They have filed a petition for withdrawal of the suit, Lordship. Yeah, and that already, because they have sought for some liberty, so we have objected to that because they want to improve their suit, Lordship. So they have already filed their petition for withdrawal of the suit. And, that is already heard by the trial court, and the case is reserved for orders, Lordship, on 30th of June, Lordship. This is my instruction. The matter has to come up after if the suit is already withdrawn by them, Lordship, only the counterclaim will remain.
And the injunction order has been passed in a counterclaim. So even if the suit is withdrawn, it does not affect the counterclaim. As per order 8, rule 6D, the counterclaim will continue to exist.
We will hear the matter.
Yes, yes,
Here
Lord.
on next.
Lordship can fix it in the after vacation, Lordship, because so that order also will come to know whether that suit has been withdrawn or not.
Okay, heard, Mr.
C. Gogoi, your lordship.
C.
Gogoi.
Gogoi, learned counsel for the petitioner, and Mr.
M. Ahmed.
M. Ahmed, learned counsel for the respondent. It is submitted to the bar that the matter is ready for hearing, and accordingly, it is read that matter may be listed immediately after reopening of the vacation.
Yes, Lordship will fix a date because Lordship, because this agricultural plot of land, Lordship, and that agricultural season.
Accordingly, it is provided that a recessal list the matter on COVID 24th July.
Obliged.
Okay, we will resume after 5 minutes.
May I please, your lordship? So I for withdrawal of 50% ordered amount from the registry of this honorable court.
Lordship, to that, we have already filed our objection, your lordship. It was filed yesterday. That was not tagged, your lordship. So I pray that your lordship, it may be taken up next week along with the objection filed by us.
What is the objection?
Lordship, we are denying liability in this case, your lordship.
Their basic allegation, they have some ground in regarding the.
Contention is that, your lordship, our vehicle was implanted for gaining undue benefit, your lordship.
Pardon?
Our contention is that, your lordship, our vehicle was implanted for gaining undue benefit, your lordship. So, your lordship, our affidavit may be tagged, your lordship. This petition may be heard after that, your lordship.
Okay, let the objection come.
Yes, your lordship, next is witness.
Heard, Mr.
B Islam lordship.
J.
B Islam lordship.
P. Islam Learned Counsel for the applicant and Ms. Borthakur for the respondent. Ms. Borthakur submits that she has filed objection. The same is not placed on record. And accordingly, it is provided that the shall list the matter on Tuesday.
Next Wednesday, your lordship, 18,
18.
18/6.
19.
19.
Lordship.
19.
What's up?
Along with the affidavit, along with the objection filed by the respondent.
Of that, your lordship.
May I please, your lordship, my lord, three I have been filed, my lord, in this case. My lord, the respondent died during this, my lord. CRC, my lord. I 2590, my lord. That is for substitution, my lord. Substitution of the legal heirs. And one, my lord, for condoning the delay. And another, my lord,
Substitution was allowed,
No, my lord, no,
not allowed.
no, my lord.
What is the IA number of substitution petition?
2590, my lord.
2590 is not for substitution. It is for
Substitution.
condonation of delay.
Yes, my lord, condonation delay and setting aside the abatement of the. Three I is there. my lord.
You come to IN number 1889 of 2025.
My lord,
IN number 1889 of 2025. This I is for condonation of delay.
Yes. Paragraph 4, my lord.
What is the period within which the application has to be filed after the knowledge about the date of the respondent?
My lord, on 3/5/25, my lord. 3/5/23, my lord.
What is the period?
Period, my lord, 3,000, my lord. 3,100 something, this in this.
No, in paragraph number 4, you have stated that there is no delay.
That is from the date of, my lord, from the date of knowledge, my lord. That is the date. From the date of knowledge.
So what is the period within which the application ought to have been filed? If you came to know about the same on 3rd of May 2023.
Yes. That's there, my lord, but condonation petition is there, my lord.
Pardon?
Condonation petition, my lord, is there, my lord. So kindly consider this condonation petition.
No. This pleas are contradictory. You have paragraph number 4. You have stated that there is no delay, in fact. And in the paragraph number
Yes, my lord, my lord.
7, you have stated that there is delay.
It was
of
filed on
3,000.
2/8/23, my lord. Yeah, substitution petition was filed on 2/8/23, my lord. And these two petition, my lord, after on 21/5/25, my lord. So as per the knowledge, my lord, it was filed within time, my lord.
Who is for the other respondent?
KK Mohanto was there, my lord. Senior counsel KK Mohanto was there.
So the other respondents appeared in this court?
Yes, Lordship.
They were.
Yes.
Any objection in
Yes, I do want to file an objection in this, Lordship.
when?
Lordship may grant me a week's time, Lordship.
Heard, Mr.
Arif Chauhan, my lord.
Learned counsel for the applicant and also heard Miss.
And Begum.
learned counsel for the respondent, opposite party. The learned counsel for the respondent opposite party submits that she may be granted weeks time to file her objection. Prayer is accordingly allowed, presence of the case maker. After 1 week.
Much appreciated.
Obliged.
Items for hearing. Item number 10, not admitted.
May it please also, my lord, this is a case for of dismissal from service by order 31/7/2018, my lord. Now, to go to the facts of the case, my lord, the allegation is that, my lord, he was found drunk and lying on the duty post, the prisoner. But there was no doctor's, my lord, medical test or anything to show that he was drunk. The prisoner case was, my lord, that he was been standing with rifle on the duty post for about 3 days continuously. So he feel his head spinned and he felt weak and fell down. That was a case made by the petitioner in his appeal. Now, your lordship kindly come to. He was recruited, my lord, in 2006 in the CRPF, my lord, CRPF, no? And 12 6 months service, my lord. Then annexer 1 page 15 is a charge sheet. Charge sheet very long, my lord. To be synopsized, my lord, it is on
So
first
the punishment imposed upon him is
dismissal.
dismissal. But the proceeding was a disciplinary proceeding was initiated for minor punishment.
Minor punishment, but there is a judgment, my lord, Supreme Court, my lord. If they want to convert it to major punishment, then there will have to be an order of conversion. But I have not found anything here unless there is anything in the record.
My lord, I'll clarify that aspect, my lord. My lord, last occasion, Lanet Senior has pointed out that though it is not in the plea, minor punishment. My lord, kindly peruse the CRPF Act, my lord.
Yes.
Only there are 19 sections. My lord, may come to contents, my lord, not contents of the, my lord, Act.
Section?
No, my lord, just contents I would like to see, my lord. Contents, my lord, first page, my lord. Here, offense and punishments from section 9, my lord.
Yes.
Section 9, offense. 9 is more heinous offenses, 10 is less heinous offenses, 11 is 11.
I also, my lord, let me, since I'm the petitioner, I'm arguing on that point. Lordship will kindly come to section 9, my lord. More heinous offenses. Has the lordship got, my lord? A. Begins, excites, causes, or conspires to cause or join in any mutiny. That is not there. B is uses or attempts to use criminal force to or commits an assault on his superior. That is not there. There are shamefully abundance or delivers of any post that which is committed to his charge or which is which it is duty to defend. There is no theft. Directly, indirectly holds correspondence with or assist or delivers any person in arms against the state. It is not there. That this obeys the lawful command of the superior. It is not so there. These are the force. It is not there. So none of the offences under this section comes under the intoxication. Now, less heinous offences, madam. Section 10. Every member says so is in the state of intoxication. First one, A. It is in the state of intoxication when or after having being warned for any duty or parade or on the line of march. It is on duty, it is said. He was intoxication. And he was warned once for intoxication on the charge of intoxication. There was minor punishment given and he was let off. That I have already said.
So on this charge, section 10A is the charge, mainly intoxication. Otherwise, none other punishments are absence himself, there is not there. Grossly insubordinate, there is not there. Only intoxication is the charge here in the charge sheet. In page 15. Now we will also only come to minor punishments. Section 11. The commandant or any other authority or officer, age may be prescribed, may, subject to any rules made under this act, award in lieu of or in addition to suspension or dismissal any one or more of the following punishments to any member of the force whom he considers to be guilty of disobedience, neglect of duty, or remissness in the discharge of any duty or other misconduct in his capacity as a member of the force. So reduction in rank, fine of any amount not exceeding 1 month's pay, confinement to quarter guard, lines or camp or term not exceeding 1 month, confinement in the quarter guard for not more than 28 days, removed from any office of distinction or a special emolument in the force. These are the minor punishments to prescribe. Because intoxication is the not a heinous charge. And generally also in the force, because they are in a very serious or onerous duty. They have to stand, and particularly central forces are very strict. I have seen in Kashmir also, the army personnel and the BSF person is standing like this, and the wind is blowing like anything. The flights cannot land after 10. So windy, but they have to stand. So in such a state of affairs, they certainly feel tired or exhausted, and also get spin in their head, and they fall down. So these are punishments. So if the authority wants to pass for major punishment, then they will have to either issue fresh charge sheet, major punishment, or convert it into major charge, major punishment. That is not there. So this is first case. Now, they will also kindly seen the charge sheet, that only allegation is the intoxication during duty hours, lying on the duty post with his gun. Now we'll also kindly come to the appeal filed by him. Punishment was awarded on 31/7/2018.
Page number?
Punishment was on the very charge sheet and punishment is given together. Now I will come to my appeal. Page 28. It is all in Hindi, we have translated to English. Page 27, it starts, the appeal is.
So there was only one article of charge.
Yes, only one. Only one. Because they could have any other article. Then what I have said in my appeal, I will also kindly come to page 28, paragraph 4. It starts from 3 matter. That the prime allegation against your appellant is that of lying in the state of intoxication by drinking liquor during the period of duty. During the course of department inquiry, witnesses deposed the state of affairs before the constituted authority from among the members of the 87th BN CRPF did corroborate the same. The incident relates to the day and time so and so. 4. That the appellant begs to state that the medical test only conducted was for the purpose of whether or not liquor has been consumed and confined and limited to the aspect that and not to any other infirmity of the body or of the person. But the accused on that relevant point of time and day was undergoing bodily dysfunction which remained in dark, and to that effect, the comprehensive medical test was not conducted. As such, the real cause that in fact befall upon the person of the accused was
So
overlooked.
medical was not conducted.
Well,
Medical was not conducted.
conducted, but only they've said it is up to the limit of drinks, whether the alcohol.
So on what basis?
But his overall body, how he was with continuous duty from morning to 5 in the evening, those things which he explained to the authority was not done. Then again, paragraph 5 also something I have repeated.
No. In respect of the SARS, article of SARS, no medical test was conducted.
No.
No.
Only matter that whether he had drunk or usually in the forces they drink. Although they can resist the climate and the hard duty. In any force matter. And it is also provided by the department. Because rum or something is to keep the body hot matter provided. So they are to drink. They will have to drink. So matter that was conducted. He might have done during the period of duty, no. Why it was before or after, it was nothing. When the medical contacted, after how many hours, nothing is there. And that I have said in paragraph 5 also. That the appellant begs to state add that on the date of mishap occurrence, prior to that continuous 3 days quarter guard. This aspect was not considered by the appellate authority also. 3 days quarter guard continuously. And quarter guard means you have to stand erect. Because you are guarding the ammunition store. That the appellant begs to add that on the date of mishap occurrence, prior to that continuous 3 days, quarter guard duty was performed, and at 5 p.m. the appellant got down and released from the duty. After taking bath, the body was feeling fatigue, ill, and whole muscles of the body began to cramping and shrinking, and there was a feeling of paralytic and as if petrifying without any sensation and stupefying. And by that time there was announcement, and I was asked to an entrusted duty at VIP gate, which was to be from 7 p.m. to 9 p.m. However, I at that first instance reluctant and expressed my inability, but I was asked that the duty was only confined to 2 hours, from 7 to 9 p.m. Thinking in terms of the short duration, somehow I ventured the risk and started the duty at VIP gate, but after half an hour, my eyes began to blink rapidly and I could not see all around. My brain began to swim and whole body was cooling down when I felt something abnormality. So this was the reason which he fell down. And lastly also he says, for 3 days he was doing the quarter guard duty. Quarter guard is a very serious duty, You cannot leave, or you cannot just even if somebody there is itching, you cannot just do it like this. It's very hard duty in the army and the central forces, unlike police duty, So these things are not considered by the appellate authority, Now, I leave, come to the appellate order. Base appellate order is Annexure 3. Page 31.
No, why this second article of SARS? Annexure 1 is also article of SARS.
Yes.
And Annexure 3 is also article of SARS. What is the difference?
16 is the order.
16, 8, 16,
Punishment.
10. 18 is the order, my lord. Order of punishment. Article charge was quoted, my lord. Only one article charge. This is the order. What I have said.
Ultimately, order.
Because I have admitted the fact that yes, I fell down. There is nothing to hide. But that part of my contention, my lord, that what was the condition of my health? Nothing is stated in the so long, very lengthy appellate order, my lord. Only it was quoted, but no finding was given there. So, my lord, the order of punishment is awarded by the Yellow Island Siege, page 37. It is quoted.
Page number?
37. That my state of health, which I have stated, that portion is reflected. First paragraph, my lord, lastly, before going to duty on VIP gate, I informed CSM of any of my persistent duty for 3 days in quarter guard and my bodily condition and my inability of further entrustment of duty. This is quoted, but there is no finding as such. The authority says that you didn't produce the record. How can I produce a recorded document on that? Then dismissal was too harsh, my lord. In any case, after 12, more than 12 years, 6 months of duty, continuous service, and ultimately, my lord, that is upheld. Passed by the appellate authority, DIG CRPF.
So page number 42 is the order, impugn order.
Yes, my lord. Impugn appellate order. Appellate order.
My lord.
That is, my lord, dismissal authority order. First, primary authority. Then appellate order is page 31.
Okay. Annex 30,
Annex, my lord, 3.
that is the impugn order.
Hello?
That is the impugn order.
This is the impugned appellate order.
Appellate order.
And impugned order I have, my lord, along with the charge sheet, page 15, charge sheet as well as punishment. Then page 15.
Page 15 is the impugn order, my lord.
Okay.
Charge sheet also quoted here. Article charge number 1 is quoted, then there is the narration. And inquiry authority has found me guilty, so I was punished. And I was given the chance to file appeal within 30 days. I filed the appeal, stating everything. Then the appellate order comes, my lord, Annex 3, page 31, dated 16/10/2018. This is the case, my lord.
So according to you, this punishment is disproportionate.
Disproportionate it is, my lord. Then and my lord, one more thing. He is too young to sit idle and too old to get a new job. He was 41 only when he was dismissed. Now he's 47. 13 years more to go to service. 60 years and 55 also, service. Huh? 69 or 55 maybe. Then he will be, I think, 15 years only full pension. I think one more thing is the one that I could not locate it. I think 15 years service entitles central forces to for constable to get pension. And then service, I think 55, isn't it? 20. 20 years. That is 6. 2026. 19. 6 years service more would entitle him to pension. 6, 7 years. Well, brother. You know?
What is the stand of the respondent authorities?
And they file my ABD with my paragraph 6 of the ABD may also be gone. Paragraph 6. Paragraph 6, Madam. What they have said, Madam, second paragraph. On 30/11/2017, individual was found sleeping. He was found sleeping because he was too tired for continuous 3 days duty plus 2 hours. He was found sleeping on the floor of the floor in a state of intoxication while on sentry duty in Morsa. And so dismissal from service was 3 days continuous duty. That is not denied, my lord. They have not denied anywhere. In the appellate order also there is nothing that no, he was not given 3 days continuous duty because that is fact, my lord. So ultimately, fact remains that he was too exhausted and tired and unable to resist the pressure on his body. Then 2011 judgment of Supreme Court matter that this punishment can be converted to major punishment. Minor can be converted to major punishment. But the record has come, I think there is not there. It is not there. There is no such order for conversion to major punishment. But after all, my lord, fact remains that it was a less heinous offense. Whether they convert or not, it is a less heinous offense. It's not that serious to call for outright throw out of a person for his service without considering his the case thoroughly and also considering the aspect of the family aspect or his half of the life remains in service.
Which judgment you are referring to?
But I am not referring any judgment, madam, but the other side will have to refer that judgment. And my simple case, madam, it is based on the act, provision of act. And the procedure followed is madam rule 27.
Earlier this matter was heard.
Yes, it's my.
By
It
someone.
was heard. One, sir.
No, here is a list of citation submitted by
Yes,
Mr.
that was on
Sharma.
disproportionate punishment. That was on disproportionate punishment.
These judgments are on disproportionate punishment.
Yes.
Okay.
No, fact
Regarding
remains, my lord,
the-
yes, my lord, that I have already admitted that I was sleeping on the floor due to overburden on my body. That is not denied. So for that matter, dismissal from service is too harsh. even otherwise also.
No, otherwise, the respondent authority has not produced any medical report that at the relevant point of time,
Yes.
you were under intoxication.
Yes,
Right?
yes.
But you have admitted that you were under intoxication.
I had admitted, my lord, no, I had not admitted. If I was intoxicated, then medical examination they have done ought to have been not only intoxication on the factor of intoxication, the state of affairs of my body ought to have been done. Certainly, what they would, before going to or after duty, they would drink. After 3 days of continuous duty, it may be so matter. Just let me explain. The practical aspect. 3 days I was standing. That is not denied by them anywhere. Neither in the affidavit, thoroughly denied, nor in the appellate order, nor in the primary order of the different authority. After the duty, when he came home, back to quarter, and he took bath, he might have drunk then. He might have drunk some liquor, my lord. Then again order comes, you will have to go to the my lord, duty for 2 hours. He first denies, I cannot now resist. But no, only 2 hours, go. He goes. Before going to duty, because during duty hours, there is a chance of drinking. Your lordship kindly know, during duty hours, when you are sent at 7 to 9 duty, there is no chance of drinking. Nobody would give him in the duty hours, nor he can after, because you have to stand guard. After he finished 3 days continuous duty, being exhausted, he has said, tired, suddenly just to relax his body, he might have drunk a peg or two. That is practical for human being. Anybody would.
No, that's all right. But is it not amount to admission?
Hello?
Is it not amount to admission?
Fair admission, matter. Fair admission cannot invite punishment, so harsh punishment. Fair admission. I could have totally denied it. No, I didn't do. Your lordship can test my honesty also. As dutiful officer of the central government, central forces. The honesty, yes. Your lordship will kindly note that practical aspect of a human being, human nature and human body. After 3 days continuous duty of quarter guard is very serious duty. You're going to leave a moment. If you have to go for urinal matter, then somebody will come, stand there, then you have to go and come back and again he is released. But if you want to go to toilet matter or necessary call, then also somebody will have to come, replace you for 15, 20, 30 minutes, then you can go to toilet.
Okay.
So, my lord, that might have been, my lord. I do not say. I do not say they should not be forced to do not drink. They drink. They might have been after the 3 days duty guard. He came when he wanted to relax, he wanted to sleep soundly. But again, the officer comes, when JCO comes and says, no, I only got it 2 hours duty. He says, no, I cannot do now. Only 2 hours, please go. Then he goes. Before that, before going to duty, he must have drunk before going to duty. Not that he got drunk during the duty hours. No, that cannot be. It is totally impossible. Who would bring him liquor to his duty post? While for the sake of relaxing himself after the 3 days duty, he might have drunk necessarily and then he was sent.
Okay.
Yes.
Yes, Mr. Parasar.
My lord, with all respect to senior, my lord, in the CRPF Act, my lord, there are 19 sections. Out of these 19 sections, my lord, there is no such sections saying that major punishment. Only section 11 is minor punishment. My lord, can you see? So until now, my lord, several persons have been, my lord, dismissed, removal, all this is done. 9 is more heinous offense. 10 is less heinous offense. And 11 is minor punishment. Now I am reading, my lord, section 11, my lord. These are, my lord, offenses. 9 and 10 are the offenses, my lord. For that, for section under section 9, more heinous offenses, punishment it shall be punishable for life and all this. Section 9 is more heinous offenses. Last after from JKL, after that shall be punishable for life and all this. Less heinous offenses shall be punishable which may extend to 1 year. Now, if we come to minor punishment, I'm reading for my consideration again, my lord. The commandant or any other authority or officer, as may be prescribed, may, subject to any rules made under this act, award in lieu of, or in addition to suspension or dismissal, anyone or more of the following punishment. My lord, may kindly emphasize that word, may, subject to any rule under this act, award in lieu of or in addition to suspension or dismissal, any one or more of the following punishment. These punishments are there. Reduction in rank, all these are there. So in lieu of means is not, my lord, that it's in addition.
No, maybe, Mr. Parasar.
Yes, yes, my lord, I'm referring to the.
No, that's all right, but dismissal, reduction in rank, dismissal from service, removal from any office, are this not a major punishment?
Yes, yes, my lord,
Though it is not described here.
Yes, yes, simple reading, my lord, it's like that, my lord, but Honorable Supreme Court has clarified to that extent. Even in our High Court, my lord, one judgment has passed regarding when it is not placed, that Supreme Court judgment, it is set aside by the District Honorable Court. Subsequently, review petition has been filed. Review has been answered in 13/2/2024. When this order has been placed, 2016, 13 SCC 71. I have the print copy of Honorable Supreme Court, I am just para 19 and 20 time. Same. Copy to nice coding because citation to 2016. 2016, 2016, 13 SCC 71. My lord, may kindly come to para 19.
Yes.
Slowly reading, my lord, para 19, my lord. The core issue that emerges of the consideration is that whether under section 11(1) of the Act, punishment of dismissal can be imposed. The controversy is no more res integra in Ghulam Muhammad Bhatt Chopra. While interpreting the section 11 of this Act, it has been held thus. A bare perusal of the section 11 shows that it deals with minor punishment as compared to the major punishment prescribed in the preceding sections. It lays down that the commandant or any other authority of the office, these are the sections, my lord. My lord, may come to para 6 of this. The use of the words in lieu of or in addition to suspension or dismissal appearing in subsection 1 of section 11 before clause A to clause E shows that the authorities mentioned therein are empowered to award punishment of dismissal or suspension to the member of the force who is found guilty, and in addition to or in lieu of thereof, the punishment mentioned in clause A to E may be awarded. Now, 7. It is therefore clear that section 11 deals with only those minor punishments which may be awarded in a departmental inquiry, and plain reading of the plain reading thereof makes it quite clear that a punishment of dismissal can certainly be awarded thereunder, even if delinquent is not prosecuted for an offense under section 9 or 10 of now para 20. We respectfully agree with the said view of the appended that under the scheme of the Act, in exercise of power, section 11(1) of the Act, punishment of dismissal can be imposed. As it's seen from the impine order, the High Court, to reverse the conclusion to the first appellate court, has extensively quoted from the decision of the Calcutta High Court under its Supra. Be it stated that the charges level against the delinquent officer there was the same. The division bench of the Calcutta High Court, analyzing the Act, especially section 10M of the various clauses of CRPF manual, came to hold that it is an admitted position from the factual metrics. These are the condition of this Act, that case, but Now, para 8 of the that considering all these issues, we are quashing the order of dismissal as well as the order of confirmation as such. Appellate authority and the remaining authority make matter may back to the disciplinary authority under the service regulations. Now, in this case, particular case, this appeal filed by the Union of India was allowed by the Honorable Supreme Court. And to this extent, this when this was placed in a review petition, this Honorable Court held on 13/2/2024. In the review petition number, review petition number 135/2022. Here, this Honorable Court earlier set aside that order, but when review was placed, review paragraph time. Para 13, para 13. That does it is observed that Supreme Court of India had held that under the scheme of CRPF Act, punishment of dismissal can be imposed in exercise of power under section 11(1) of the Act. So, para 17, as the Supreme Court of India had already held and in the hearing of the before referred to the cases Golab Mahmood so Dilar Singh Supra to the effect that under the scheme of CRPF Act 1949 in exercise of power under section 11(1) thereof, punishment of dismissal can be imposed. The decision of Supreme Court of India would be binding to this court as per the provision of Article 141 of the Constitution of India and all this. So accordingly, that review was allowed. Now, in this case also, and that was not the projected case at that time of the petitioner. However, when last occasion it was argument, it was placed at section 11. But I have.
But there are also some decision of the Supreme Court that initiating the departmental disciplinary proceeding for minor offenses.
In the particularly CRPF Act, because of that, I have shown the contents. There is no such sections saying major punishment. These are the section 9 and 10 are the offenses. In that more heinous offenses, the punishment up to life can be given. Less heinous offenses, punishment of 1 year. Minor punishment, I am again reading, award in lieu of or in addition to. In addition, so it is in addition to these two, suspension or dismissal. These two can. In addition, from my understanding, I have understood this in any case, CGM has given to 7 years all this. Session judge can life also. Whether session judge can give punishment 7 years on all this, and if we say session judge cannot do life on all this, so there is no such section in the CRPF Act saying major punishment. In the same section itself, it has been given award in lieu of or in addition to suspension and dismissal. And when the Honorable Supreme Court has clarified.
Except his admission, is there any evidence to show that at the relevant point of time he was under intoxication?
I have the record, origin record. There are photographs also. And
No, photograph will
Yes.
not prove his
Yes,
that
Malak.
he was in drunken
Yes.
condition.
Sarge was there, not only in drunken condition, he was sleeping, and more effectively, his light machine gun. LMG was also lying unattended. When he was a Morsa duty, his gun is lying unattended. That is also one of the search. And
No, there was only one article of search.
yes. In that article itself, during the duty hours, he was found lying unconscious and also on that floor of his duty, and his personal weapon LMG were lying unattended far away from his body. That is the whole charge. And yes, regarding his confession, yes, in Hindi, मैं ड्यूटी में सोया हुआ था और शराब पिया हुआ था और मुझे नींद आ गया था. That is my lord, I am not reading whole, my lord, sorry, in Hindi. And
That is there.
that is, and regarding doctor's evidence, one, I am not finding, one, it was actually. As per the record, my lord, medical officer দ্বারা কি হওয়া দিনাঙ্ক 30/11/2017 medical officer দ্বারা প্রাপ্তি হওয়ার আছে। মানে he was
Page
examined
number,
by the medical
is it
officer.
part of the record?
Yes, yes, not in that, my lord. Here it is in the original record with me, my lord. Medical officer is examined on 30/11/2017. No. 17 can you go?
30/11 is the offense date.
No, sorry, my lord. That is
30/11 is the offense date, my lord. When he was found.
30/11.
30/11 was the.
On that day itself, my lord, he was examined by the medical officer. But that report, he was examined, that is mentioned in the, my lord, note, but the medical officer.
No, is there any finding of the medical officer that he was under intoxication?
That, my lord, I am searching in the record. All are in Hindi because of that, my lord.
All are in. It's very difficult to decipher for us.
But that is their medical officer द्वारा किए गए जिन्हें medical report का प्रति. So that is there, but and if it's not there, my lord, I have to, my lord, Vibhaga just.
No, whatever is in the record, that will be there. You cannot bring it.
How we now? এখন কি? যা সে দিছে।
My lord.
My lord, regarding that, my lord, only regarding that, my lord, medical, it is reflected in the my lord, inquiry officer's report that medical.
No, maybe.
But
Where he got the same?
Yes, my lord, that report is I have Parambic preliminary inquiry. Procedure has been done, but maybe, my lord, maybe as in Hindi, we have some difficulty, but for this specific query, my lord,
Let it fix next week, my lord, on particular date.
Next week.
It will be in part, my lord.
otherwise, my lord, only getting that, my lord, medical officer's report, my lord.
Meantime, there is certificate in the morning of court.
No, but to establish the search, there must be some documentary evidence to show that he was at a relevant point of time under intoxication.
No, my lord, the one thing is there, my lord. To show that he was intoxicated during the duty hours. That has to be proved, my lord. Even by oral evidence, they can prove whether he had taken during duty hours or after the end of the 3 days continuous duty, while he was in his quarter relaxing. If he has taken during that time, then 2 hours duty was posted to him. If it is before the allotment of duty, then things will turn.
My lord, there are evidence of the persons are there.
Yes, that is there. He was
Evidence of
drunk,
the
it
persons are there.
is there.
In the-
I have also said so. There is not that.
No,
But
not-
if I had drunk after 3 years duty, 3 days courtesy duty, then I was relaxing. Then officer comes and said, now again you are posted for 2 hours duty. Then things will be different. And in the 2016 and 13 SCC, the judgment, the offense was absenting from duty without leave. Absenting from duty for a CRPF or any armed forces is a very serious offense. It is simply intoxication and sleeping.
Statement of the other persons are there, my lord. That is there, my lord. He given the opportunity.
All are there.
They are the eyewitness of his consuming liquor.
One thing I have seen, my lord, that none has said that he drank during the duty hours. He didn't drink. If he drank before the duty hours, So as to take rest, then matter will be authorized.
Okay, then
Well,
we
I'll
are
clarify
listing
to-
the matter on next week. if Mr.
Madam,
Parsons, obtain his record.
And one more thing, my lord, all the original documents, my OBC certificate, SSR with them. My son's admission and my children's admission could not be, those documents could not be produced. So in the meantime, let them release those documents. Yes.
Directly. Well, his documents, well, yes.
You can even give it to my junior today or tomorrow, so that the children can take admission. Because he is OBC.
Heard Mr. R.P. Sharma, learned senior counsel, assisted by Mr. T.N. Sharma, learned counsel for the petitioner. Then Mr. K.K. Parasar, learned CGC. For the respondent. Heard in part, list the matter on cover next Tuesday, 26.
26 last সপ্তাহ তো হেৰি হ'ব নেকি
26 is
24
24.
24.
Okay, 24.
In the meantime,
In the meantime, Mr. Sharma, no, Mr. K.K. Parasar, learned additional, no, learned CTC shall obtain instruction as to whether there is any medical report to show that at the relevant point of time, the petitioner was under intoxication.
Yes.
and any eyewitness also well regarding
That's on record. You need, you can put it in your, Mother, in the meantime, let them return the certificates.
record matter I have to say to the department matter I'll
These certificates may be returned, madam. Original certificates.
Original record.
No, certificates.
his certificate with the department malata earlier occasion Lanet Senior has placed that submission
Because
I'll ask them to bring those
Next day, we will take a call up.
in the code itself I'll provide
Yes.
Okay.
All right, before that, if you can leave. Only for the admission of the children.
They also just have there was a little alteration between me and my friend Mr. Titi Tara also on that point only. The clarifications which have been given by the finance and account officer by the pension audit and pension department, that is lordship. May I read lordship?
Yes.
I think that has not been placed before the summer court, but this clarification was already given to me by this day only. In inviting a reference to our earlier observation raised by our letter given under reference in respect of Sri Tagong Ketan, Chief Engineer PhD, the following rectification have been made. Order dated number so and so 19/7/2000 in place of order number so and so observation. SC in place of EE in observation. In that case, what happened, lordship? He was already promoted to lordship post of SC. Before lordship, during the period of probation only itself. Therefore, they are not similarly situated person, lordship.
Yes, Mr. Tara, how do you explain it?
No, my lord, kindly come to my rejoinder.
Yeah.
My rejoinder is at
Annexure 3.
correct, my lord. You see, my lord, the question that I urged was, by that relevant point of time, it was not mandatory for the officer who has been promoted to the executive engineer to pass through the account examinations. So therefore, the same year, my lord, in 2000 only, the petitioner was promoted to the executive engineer. And by that time, that particular letter, particular OM was enforced, my lord. That, my lord, just I find it out.
No, Mr. Tara, this letter relates to RWD department.
My lord, now what happens is
Yes.
there is a common recruitment rule for engineer works department of Arunachal Pradesh. Now this is called common recruitment rules for engineers in Arunachal Pradesh, my lord.
Yes.
So therefore, my lord, to my respectful submission is that the petitioner by at relevant point of time has promoted, my lord. And then that OM was still in operation. Then, my lord, for clarity, let us read this particular thing, my lord. 103, my lord, that 101, my lord, annexure 3.
Yes.
Sri Tagong Khetan CEPHE. On re-examining the service book of the incumbent, it appears that the passing of the departmental account examination for AEEE had been made mandatory with effect from 10/08/2001, wide order number RWD 2000. As the officer has already been promoted as EE before the cutoff date, passing the departmental account examination, the question of passing departmental examination for AE/EE and recovery of excess drawal of pay and allowances therein does not arises as mentioned in our earlier observation wide letter dated so and so. Now there is a typographical grammatical mistake is there in this letter. Let us forego. 2, my lord, DNI of incumbent falling in the pre-revised scale during the month of May 2006, as one additional increment may be allowed in the pre-revised pay, and then the pay may be refixed at rupees so and so. Now, my lord, because this has superseded earlier order, my lord. Now, even then, my lord, kindly see. Now, kindly come to page 99 as well, my lord. Page 99, my lord, serial in the box, my lord will find serial number, column number 2 and 3, my lord. This will make it more clear, my lord. Now, my lord, there is one more thing.
Mr. Tara, it is page 99 of the writ petition.
No, my lord, rejoinder.
Rejoinder.
Yes, my lord. Particular.
No, page number 89 is the last page of your rejoinder affidavit.
No, my lord, is page 89. No, my lord, page 99. Page 101 is my last thing.
There is correction.
Yeah, because like other day also that my brother Tapin was telling that there was some mistake in that. Well, he has not given me the correct.
Referring to page number?
My lord, will see last page of my rejoinder, my lord. There are two markings, my lord. One is at 97, one is marked as 97, and another is marked as 101.
Yes.
My lord will take it as a face value of 101, my lord.
Yes, 101, just you have read it.
Yeah, that's why. That one, my lord. So, my lord will read here in after as 101 instead of 97, my lord.
Yes.
Kindly remove 97, my lord.
Okay.
Now, my lord will see. Well, let me point out this particular thing. My lord, kindly see, I was promoted as executive engineer on 03/10/2000, my lord. That, my lord, will find in my read petition, my lord. I was promoted as executive engineer on 03/10/2000, my lord. My lord, you'll find that file noting in page 87 of my read petition, my lord.
Yes, got it.
Yes, my lord.
So there was ad hoc promotion on 25th of September 2000.
Yeah, my lord, the service law is whether you are ad hoc or the regular.
No, that's all right. No
For
problem.
the purpose of seniority and the pensionary benefit, it will be counted from date of your officiating or ad hoc promotion, my lord. So therefore, any consequential law or the OM that has to be applied against me cannot be retrospective, my lord.
Okay. Okay.
Page 87
That's all
of my...
right. But Mr. Tara, the question is whether this order dated RWD stroke SECTT stroke 11/2000 dated 10/8/2001 is applicable in your case?
That is applicable in my case.
Yes.
Because they have a common engineering cadre service, my lord.
Yes.
So because parity comes in, my lord.
Yes. Yes, Mr. Tapene, is it
Lordship,
applicable in the case of the petitioner?
Lordship, kindly come to page 101 of the rejoinder filed by the petitioner, Lordship.
Yes,
Annexure 3.
101. Yes.
Correct.
Just like, may I read, Lordship, one?
Yes.
On re-examining the service book of incumbent, it appears that the passing of the departmental account exam for A/E had been made mandatory with effect from 10/8/2001 by the order number so and so and so on. Lordship, kindly it be noted that, Lordship, this 10/8/2001, what is this notification, Lordship? This is for another department, Lordship. This is not relevant to the present case.
Okay.
Therefore, Lordship, that they also just I put a question to my friend Titi Tara.
Yes.
What is this this order dated 10/8/2001? Whereas in the present case, Lordship, if Lordship come to the page, Lordship, page 50 of my affidavit, this is the order dated 19 July 2000.
Page number?
Page 50, Lordship, Annexure B.
50.
What I'm submitting is, Lordship, in the present case, Lordship, the mandatory of account examination, passing of account examination was made mandatory on 19 July 2000, Lordship. Whereas the case which my friend has referred, Annexure 3, it's talk about the 10 mandatory with effect from 10/8/2001, Lordship. These are completely two different documents. One is not relevant to the present case, Lordship.
Well, that is what I am countering to the senior government advocate. I don't know whether he is on the right footing of argument or not. Kindly come to the same page, my lord, Annexure B, which he is referring to. This is with regards to, my lord, I am reading for his clarification.
Okay.
Pursuant to adoption of norms and procedure of CPWD manuals by all works department under the government of Arunachal Pradesh, the departmental examination in respect of assistant engineer and junior engineer in the Department of Public Health Engineering and, my lord, here it is a case of assistant engineer and junior engineer. Where is the question of executive engineer passing the account examination, my lord? With greatest respect, my lord, I differ with his submission, my lord. This is only in respect of assistant engineer and junior engineer, my lord. Nowhere it talks about the executive engineer. So therefore, my lord, the page 101, which I have, the rejoinder which I have filed, comes in my favor as a parity, my lord.
Lordship, one small correction, Lordship. The same order dated 19 July 2000, Lordship. Lordship will find in the second paragraph, Lordship, consequent upon issue of this order, the apex of departmental examination or increment in respect of A/J will be regulated under the provision of
I am not disputing on this. This is only for A and J.
CPW manual, Volume 1.
what I'm submitted on that day also, Lordship. So far, CPW volume number 1 is concerned, the extract I have already annexed as annexure 1 in this very affidavit, where, Lordship, even the executive engineer also is included, Lordship. This CPW manual is already applicable in our state and which regulates the, Lordship, which regulates the service of the petitioner also, Lordship. That's the executive engineer, Lordship.
But
Let's kindly
Mr.
come to
Mr.
annexure,
Tapin,
Lordship.
Mr. Tapin, can you tell me since when this CPW the manual came into force in your state?
Lordship, that part, Lordship, I need to take instruction, Lordship. Otherwise, it's already applicable to our state,
So
Lordship.
that's all right, but since when?
That part, Lordship, I have to see, Lordship.
Okay.
I think
kindly,
my brain will not
my lord,
dispute
kindly
on that,
come
Lord.
to page number 65, annexure E. This is AO by them only. Where it is.
Page number 65
Yes,
of your
yes, my lord.
petition.
No, is affidavit in opposition.
Okay.
My lord, how this CPWD manual is made applicable commonly for engineering services in Arunachal Pradesh, my lord.
Yes.
My lord, kindly see, that is order dated 22/10/2010.
Yes.
The departmental chief engineer PWD are the Western Zone Hydropower, common address to all the chief engineers.
Yes.
It says departmental examination for JEs, AEs, EEs as per CPWD manual volume 1.
Hmm.
CPWD manual is followed by all engineering department as also other department in relation to the execution of work. At the same time, as per Rule 13 and 14 of the manual, departmental examination for JEAs, stroke EEs and equivalent posts having degree diploma in engineering as basic qualification for appointment is compulsory to grant annual increment. In this regard, the following information is required to be furnished: whether all works department are following the laid down norms and procedure before grant of increments, etc. to JEs, AEs, or equivalent post, whether so and so. So, my lord, now what had happened is, kindly see, this has been made effective from 22/10. And whereas my promotion, my lord, it has come on this date. I was made my just 17 days prior to coming into force of this particular notification. On 3/10/2000, I was promoted, my lord. So therefore, the scheme of my argument fits into the page 101, my lord, of my rejoinder, my lord. Kindly see. Then, my lord, there is one more thing, my lord. Now, kindly see page 68 of their affidavit in opposition by R4 and this thing, respondent number 2 and 4. Annexure D, my lord.
Annexure number?
Annexure D, my lord, page 68 of the affidavit in opposition filed by respondent number 2 and 4. That is Audit and Pension Department, my lord.
The problem is that there is a mismatch in the number.
No, my lord, that's affidavit in opposition by them only, my lord. Respondent number 2 and 4. We were in that page only, my lord.
2 and 4. Page number annexure?
Annexure 68, my lord.
Yes, annexure number 2.
No, my lord. Kindly see the rejoinder of respondent number 2 and 4.
Your rejoinder.
No. By them, affidavit in opposition by the respondent number 2 and 4.
Yes.
Well, earlier, a while ago, we were reading that page 65, then thereafter 68.
No, in the affidavit filed by the respondent number 2 and 4, there are only two annexers, annexer 1 and annexer 2.
Well, this is by 1 second, well, just I confirm, but yes, Melo, this is by the respondent number 380. In 386, Melo, you will find this. Yes, Melo, I'm very, I'm sure it is by respondent number 2 and 4, Melo.
Yes, it is 2 and 4. Yes.
Yes, 65 we have already read, Melo.
Affidavit dated, Mr. Tara, is it the affidavit dated 27th of January 2025?
This is
27.
27, Melo, 27 affidavit last part, Melo. I just, well, for a moment, Melo. When he has given this, I'm reading the affidavit of 4th October 2024. It is by respondent number 2 and 4.
Yes.
Now, my lord has seen this. Page 68, I was requesting my lord to have an indulgence to page 68, my lord.
There is no page number 68 here.
Annexure D, my lord, is having.
Yes, there are two affidavits filed by respondent number 2 and 4, and one is 1 and 3.
My lord, I'm referring to affidavit in opposition by respondent number 2 and 4
Yes.
on 24 October 2024.
But it is updated 27th of January 2025.
My lord, that copy I am not having in my liquid text, my lord. My lord, kindly try to have this copy of affidavit in opposition by respondent number 2 and 4, my lord.
Yes, it is available with me.
My lord will kindly cross-check with the date.
Yes, that is 27th of January 2025.
No, my lord, there's the one which I am having is, my lord, one I am having is page 55, my lord, will see. That is signed on 4th day of October 2024 at Guwahati High Court premises, UPI. That is by one Durgavati Taba, my lord.
Okay, you are referring to annexer?
Annexure, my lord, first one I referred at page 62, my lord, annexure B.
Annexer D.
B for Bombay, my lord.
Yes.
This is in response
The
to
order dated 19th of July 2020.
correct, my lord. This is in response to Lordship's earlier question as to whether executive engineer is required to pass the departmental account examination for getting increment.
Yes.
So, my lord, these letters suffice and clarify my position, my lord. Kindly see, my lord. Pursuant to adoption, that is letter dated, order dated 19 July 2000.
Yes.
Pursuant to adoption of norms and procedure of CPWD manual, CPWD examination in respect of assistant engineers and junior engineers, my lord will mark this word assistant engineer and junior engineer.
Yes.
Engineers in the Department of Public Health Engineering and Water Supply, the department from where I superannuated as superintending engineer, my lord, is hereby enforced as per provisions of CPWD Manual Volume 1 in toto, and in the same line of procedure adopted in AP PWD for conducting such departmental examination for release of increments, etc. my lord. So now, my lord has seen, this was only in respect of, by that particular time, it was mandatory for the assistant engineer and the junior engineer to pass the departmental examinations.
Yes.
So that is what, my lord, I was referring to. My lord, kindly next, kindly come to, I was promoted on 3/10/2000, my lord. 3/10/2000, my lord, I was promoted. Then, my lord,
But Mr. Tara, you have mentioned it in your petition that you have there was ad hoc promotion on 25th of 9/2000.
correct, my lord. So what happens is, my lord, for pensionary benefit, it is no more res integra that your ad hoc or officiating promotion shall be counted for the pensionary benefit.
No, that's all right. There is no dispute on that point.
Yes. Now, my lord has second question which my lord has asked me is whether when the CPWD manual was made effective, my lord. So that part, my lord, I am coming. My lord, kindly come to this page 87 of my read petition, my lord.
Yes.
My lord, will see page 87, the note number 1, my lord.
Yes.
Tamoli Tako, SCPHE Circle Pangin regarding a request for examination from passing of departmental account examination and along with certificate of good service records, which may be seen. My lord, kindly see that I will be coming to their affidavit in opposition by R2 and 4, where it is only the chief engineer who can, Director General of PWD only can grant this. Now it says, it is seen that the department has submitted his service book for IPS initial pay scale checking to the Director Audit and Pension Government of Arunachal Pradesh, Naharlagun, since his retirement is due on 30th April 2023, wherein Director Audit and Pension returned his service book with observation that there is no record of passing of departmental account examination in the service book during the period of executive engineer. Hence, they directed the department to recover the excess drawn of salary with effect from 01/10/2002 to 06/2011 till the promotion to the superintending engineer. In this connection, the incumbent was promoted from assistant engineer to executive engineer on 3/10/2000 wide government order number so and so, dated so and so, and promoted from executive engineer superintending engineer on ad hoc in 2011 and regularized by so and so. Although there is departmental account, my lord, next paragraph. Although there is departmental accounts examination prescribed for junior engineer, assistant engineers, and executive engineers as per CPWD Manual Volume 1, but PHE and Water Supply Department was adopted departmental account examination wide government order number PHE so and so dated 16/8/2000. That is for assistant engineer and junior engineer, which is clearly mentioned that the departmental examination in respect of junior engineer and assistant engineers of the Department of PHE and Water Supply is enforced as per provision of CPWD Manual Volume 1 in toto. And as per aforesaid government order, there is no provision for executive engineers level to appear departmental account examination, which may be seen at so and so. In this regard, the excess salary drawn recovery in respect of Tamali Tako SC does not arise in that. My lord, these are the documents that we have obtained through RTI.
Mm.
Law is well settled that government cannot go against its own documents, my lord.
Mm.
That part, my lord. Other day also, I made an exhaustive submission to this case, my lord. Now, my lord, kindly come to the affidavit in opposition, which my lord has had a while ago by respondent number 2 and 4, my lord.
Mm. So this is the office note of the department.
Correct. Official record is very loud and clear, my lord.
Mm.
I am not required to appear the accounts examination for the executive engineer, my lord.
Yes.
Now, my lord, who are the person who has the competency to waive off the departmental examination if an officer is not has not cleared? So that, my lord, will find at page 68, annexure D of the affidavit in opposition filed by respondent number 2 and 4, my lord. Combined.
Yes.
My lord, see, office memorandum dated 28 August 2017.
Mm-hmm.
The provision contained in para 6.2 of CPWD manual, regular establishment and office procedure. In the, my lord, left side, existing provisions, my lord, will see. Then amended provision, my lord.
Yes.
I'm referring to amended provision, my lord. Kindly see the 1, 2, 3, 4, 5 lines. Exemption, my lord.
Yes.
Exemption from passing the departmental examination will be considered on case-to-case basis. Exemption will be granted by a special Director General Headquarters CPWD, subject to the officer fulfilling the following conditions. Officers should have reached the age of 57 years. Now, my lord, kindly see, at the verge of my retirement, the first criteria in 2024 only, they have pointed out that I have not cleared the departmental examinations. On this first condition prescribed, my lord, I qualifies. Secondly, my lord, he should have good records of service, my lord. That also I have provided, my lord.
Mm.
My lord, kindly see, my lord. I constrain myself from making any harsh observation. My rejoinder, my lord, is very loud and clear. Therefore, my lord, this read petition deserves to be allowed on this count. Because you cannot adopt a different yardstick for different person.
Mm. Okay. Mr. Tapin, any reply?
Lordship, kindly come to page 53 of my affidavit, Lordship.
50?
53, Lordship, annexure C. The affidavit filed by respondent number 2 and 4, Lordship.
Okay.
53, Tapin?
Yes, 53.
Okay.
Lordship, may I just read, Lordship?
Yes.
This is the, Lordship, the instruction issued by the Finance Department. This is only the reminder, Lordship. Lordship can see the CPW manual is being already followed, Lordship, in our state, Lordship. It's being followed by all the engineer department as also other department in relation to education work. At the same time, so and so and so, for department again, so and so, a equivalent post is already being, Lordship. This is already being followed, Lordship. Now, what instruction has been given is a paragraph 5, Lordship. The department may mandatorily furnish a certificate to Treasury officer concerned, signed countersigned by the head of the department concerned in respect of clearance of departmental examination by so and so, and equivalent post SL. So this is only the reminder to them to do this thing. It doesn't mean that from this day, Lordship, this CPW menu has been made effective, Lordship. This is only the reminder, Lordship.
Now, if you say so.
And please just let me complete first. Then kindly come to, this is only a reminder, as Lordship is very clear from this language. On the page of the record, it's very clear, it's being followed by all the engineers, engineering department, Lordship. Then Lordship kindly come to annexure A, this page 44, Lordship. which is the exact copy of CPW Manual Volume 1, Chapter 4, Lordship.
Yes.
It starts from page 44, Lordship.
Mm-hmm.
This is a CPW Manual, the exact copy. Then kindly come to relevant one, that is page 47, Lordship.
No, 1 second.
Page 47. Lordship,
My lord, I
Yes, got it.
have umpirement because
departmental
the-
examinations
the-
for assistant engineers and executive engineers, Lordship. The Director General of Works will arrange to hold the undermentioned examination each year or at the so and so necessary. Here, Lordship, the for executive engineer is given there, Lordship. Then kindly come to next page, Lordship. Note, Lordship, may kindly see, come to the note, Lordship. Note 1, Lordship. Every executive engineer and assistant engineer, including so and so, shall have to pass the departmental examination irrespective of age and length of service. Then kindly come to serial number 4, Lordship. Serial number 4. The engineer official, yes. The serial number 4, Lordship. The engineers officials promoted from one grade to another will not be allowed to draw increment in the scale of the pay of the post to which they are promoted until they have passed the departmental examination prescribed for the grades from which they are promoted, Lordship. Here, Lordship, is clear instruction has been given, provided in the CPW manual, Lordship. What I'm submitting is, Lordship, in our 2000, Lordship, that letter, though the name of the executive engineer is not there, Lordship, but this CPW manual is already being followed in our state. Therefore, Lordship, when the petitioner is being governed by CPW manual,
Memorandum issued by the government is silent on that point. Why there is no mention of executive engineer there?
Correct.
But it doesn't mean that, Lordship, this will, Lordship, when
No,
it's
no,
not
Mr.
included, doesn't
Tapin,
mean
if
that,
it is
Lordship,
not
it
there in the
discard the.
office memorandum issued by you, can we presume that it is there?
No, Lordship, what I'm submitting is, Lordship, when this order dated 19 July 2000, Lordship, it doesn't include the executive engineer, but it's silent on that. When it's silent on that, they are already being governed by Lordship, CPW manual. That's what I'm submitting, Lordship.
Yeah, correct.
But by this order, the application of CPW manual upon the executive engineer has not been discarded, Lordship. This is in respect of assistant engineer and junior engineer, Lordship. Whether it's issued or not, otherwise also they are being governed by the CPW manual, Lordship. That's what I'm submitting, Lordship.
Anyway, Mr. Tapin,
And
you
one
come
more
to
thing,
this.
one more thing,
Tapin,
Lordship. This order, it cannot.
You come to rejoinder affidavit filed by the petitioner. That is Annexure 1. The office note where it is stated that excess salary drawn by the petitioner and the recovery in
Lordship.
respect of him does not arise.
Lordship, Annexure 1.
Annexure 1.
Lordship, one thing we must be very clear, Lordship. One is the law, Lordship, and one is the opinion of the Lordship official concern. Opinion of the officer concern will not supersede the law, Lordship. That's what I
That's
understand,
all right.
Lordship.
That's all right. But on what basis this note was put up then?
Lordship, because we have not received any instruction on this rejoinder. So,
No, the
but I
rejoinder
understand, Lordship.
affidavit was already furnished to you.
That is correct, Lordship. That is correct, Lordship. Lordship, what I'm submitting is this honorable court being a court of law, Lordship, we have to go by the law, Lordship. The opinion of an official may be, Lordship, vary from table.
Mr. Tapin,
That may
you
be.
see, this office note is against you, and the notification issued by you pursuant to the
19 July
CPWD
2000.
manual is silent in respect of passing of the account examination by the executive engineers.
And the
And
lordship,
there is
they
also
part,
another notification issued by you that it is not applicable in case of those who have joined, who have been promoted after 2000.
If lordship assume that lordship by order dated 19 July 2000, the CPW made has been implemented in the state of Arunachal Pradesh. In that case, lordship is correct, lordship. But what I'm submitting is that by this order, CPW manual has not been made applicable. Prior to this, already is in application, which govern the engineering services, lordship.
My lord, may I just give a quick response?
This is very lordship, crucial issue which I have just now I have pointed out, lordship.
Correct.
I am reiterating that, lordship, by order dated 19 July 2000, lordship, CPW manual has not been implemented in our state of Arunachal Pradesh. Prior to this, already this CPW manual is already in application, lordship.
Okay.
And this does not, this lordship order does not touches the lordship race, terms and condition or guidelines provided under the CPW manual, lordship. That's already in application, which govern the engineering services, lordship.
My lord, just 1 minute response to my brother Tapin submission.
Yes,
My lord.
yes.
He said कि although 19 July 2000 notification issued by them is silent about the applicability of CPWD manual in Arunachal Pradesh in respect of EE, but it was only a reminder which he says. No, please, Tapin, please, you have done enough.
No.
Let-
That's not my submission. That's not my submission. My submission is that, lordship, if by order dated 19 July 2000, if we assume that CPW manual has been made applicable in our state, then lordship's observation and my friend's submission is correct. But what I'm submitting is prior to 19 July 2000 also, CPW manual was already in application. which
Already
governs the
applicable,
lordship
correct,
services of engineering
correct.
services.
It is already correct, already applicable. My lord, the irony of his submission is, we'll find the answer at page 101 of my rejoinder, my lord.
Okay.
101.
Okay. Okay. Heard Mr. T.T. Tara, learned counsel for the petitioner, and Mr. S. Tapin, learned senior government advocate for the respondent authorities. Argument concluded. Order reserved.
Close.
Grateful, my lord.
Okay, all right.
Thank you, my lord.
May I pray for a little bit of indulgence, my lord, with regard to item number 12, my lord?
Yes.
We have a joint term prayer, my lord, in this matter, my lord.
Item number
12, my lord. Can it be taken up after the vacation?
As agreed by learned advocates of both the parties, recessal is the matter immediately after reopening of the vacation.
My lord, if any date may be picked.
Take a date from it.
Much obliged.
29 July. Pending item 2.
Lordship, this is relating to non giving the benefit of the UGC pay scale to the petitioner. While he was appointed in the year, but not initially but in 92, and his approval was given by the director in 94. At the relevant time, my lord, there was no NAT or slate use requirement is there. And in spite of that, my lord, the condition was imposed upon the appointment letter. That is, my lord, the Annexure 1 or Annexure 2 is, no, my lord, this is 2 is the advertisement. Annexure 3, my lord, at page 29. That condition was imposed there until my lord I clear the NET, this MPhil or PhD, I'll be not entitled to for any, my lord, the benefit of the scale revise and promotion and other things, and I'll be only entitled for 2,200 as a fixed pay, my lord. That is my scale.
Yes.
And after that, my lord, there was no such condition, but at the same time, my lord, in the same college, in person of the same advertisement, there is a 3 advertisement for post. One is, my lord, political science, one is Assamese, and one in economics. The lordship will get in annexer 1, annexer 2 at page 28.
Yes.
It is a second advertisement, my lord, regarding, my lord, the secretary Madhya Kamrup College, where it is specifically stated the application with status that copies of the certificate and the mark sheet from the SLC onwards will be received by the undersigned up to such and such for the sanction post of the lecturer in Assamese Group B, Economics Group Demography, and Political Science Group A. So, my lord, in the person of the same advertisement, well, the process for appointing the three lecturers in this say 3 departments are initiated, and on the basis of that, well, on the basis of my, whenever I will be, my lord, come out as a successful, my lord, the first nominee, then I was appointed, and that, my lord, that letter that was annexer 3, by which, my lord, this approval was granted to my appointment, my lord, by Gov letter number such and such reference. Lordship will kindly have a look the reference, your letter, such and such resolution, then Gov letter number such and such 6/7/1994. So by which, my lord, I was given the appointment, and that condition I have already, my lord, narrated in lordship, that I have to obtain the MPhil or a PhD within 8 years. So that was, my lord, not the condition applicable at the time of the relevant time as per the UGC norms to draw the UGC salary, my lord, UGC scale. So subsequently, my lord, what happened in 2007? My lord, as my lord, I am not entitled to get the, my lord, whatever, my lord, the salary was given, I was entitled for the UGC.
No, here it is clearly mentioned that you have to obtain MPhil or PhD within 8 years.
Yes, my lord.
Failing which your service will not continue.
Continue. But the thing is that, my lord, that condition is not applicable to me, because at the relevant time, this is a qualification of only 55. And on the basis of that, my lord, lordship will come, I'll come to the another appointment letter in the same college and in person with the same advertisement, and another appointment letter I have filed another by additional affidavit. That condition was not there. That condition was not there, and the condition for clearing the NET and slate, in place of the NET and slate, if somebody is acquired the MPhil and the PhD as per the recent guideline also, that is acceptable, my lord. But MPhil has gone after 2009, but PhD is still continuing. If it is I obtain the PhD, my lord, due process of selections and, my lord, interviewed and coursework, then, my lord, I will be entitled instead of the NET and slate, I can be appointed. That I am not on that, but I am on that day, that the day of the appointment, that is in 94. What was the UGC regulation says the minimum qualification for appointment. So minimum qualification appointment on the that of, my lord, this is only 55%. My lord, and other good academic records. So on the basis of that qualification, I was interviewed and I was given the appointment. Lordship, my lord, kindly have a look at, my lord. And this is a straightway. I am not giving so much time to lordship, because they have also admitted the same things. And I have also annexed the document, my lord, 2013 January 2000 in Assam, my lord, UGC regulation regarding the application of the NET and slate was applicable, my lord. That they have made applicable from 13 January 2000 only, my lord. So kindly have a look, my lord, the annexer 12 at page 43. Same advertisement, same tenure, my lord. In reference of the same number, the sanction number also same, my lord. In persons of the said resolution number 5, taken by the governing body of the college, dated 18/7/93, the service of the following incumbent hereby approved. Here, my lord, Bhairav Chandra Das, that is economics. My lord, I have already mentioned there is one post for economics. So he was given the appointment. There was no such condition was there, my lord. And the lordship, a newly appointed incumbent is required to submit their joining report against their appointment along with the other resolution required for the submission of the approval. the salary of the newly appointment incumbent will not be given until and joining the report is approved by the office. That was my lord. No any, my lord, adverse, my lord, conditions or my lord, harsh condition was imposed in that, my lord, in respect of the economics lecturer. And similarly, my lord, I have filed another, my lord, the affidavit in my reply to the, my lord, the affidavit filed by the, my lord, government director, where in page, my lord, 71 of running page, my lord. Earlier, I have mentioned the economics subject. Now, my lord, I am coming on the Assamese.
Page number?
Page number 71.
Yes.
Where, my lord, in case of the Assamese, Sri Koilas Das, he is already retired from service, my lord, after getting all the benefits. The Assamese, my lord, same condition, my lord, as my lord, in the case of the economics. But the condition, whatever is imposed on me, that I have to clear the MPhil or PhD, that was not there. And admittedly, my lord, they have filed their affidavit by which, my lord, they have stated, Lordship will get pays
No, you are referring to page number 71?
one earlier.
71.
Yes, my lord.
71 of your affidavit in
Reply.
reply. Affidavit in reply.
Yes.
That your the page 71 is one annexer.
Annexer, my lord, 3-2, my lord.
Annexer 2.
Actually wrong annexer, my lord. That should have been continuation. But even that, my lord, this is annexer 2, it is shown. Page number 71, my lord. Last but one, my lord, affidavit, my lord. Page, my affidavit.
Yes. Annexer 2
Annexer 2.
is in page number 79 here.
Probably, my lord, there is some mistake on.
But, these are very difficult for
But because
to
sometimes what
reconcile.
happened, my lord, they
So one pagination is in your documents, one is in his, and another is before me.
my lord, what happened, my lord, sometimes whenever the filing was done, my lord, properly, my lord, pagination was not continuous. So this
But
is because I have
go
filed
to
the
the record and rectify the same.
but rectify, my lord, because I have continuing, my lord, this para as per the affidavit filed by the, my lord, this government, my lord.
Yes.
Government, and after one affidavit by the UGC. So that is why I'm now correcting, my lord, these things.
So this Koilas Das was appointed as
Same,
lecturer in Assamese.
lecturer in Assamese. At that time, there were nomenclature was there, lecturer. Now it has been changed as an assistant professor, my lord.
Assistant
Assistant,
professor.
initial appointment entry.
And he was appointed in the year
My lord, 94. Same.
94.
94. Same,
And
along with
there is no such condition.
no condition. That is the same advertisement. Same advertisement, my lord. Only the interview board was different for different subject. And the even the, my lord, number that is also continuing the whatever they are, my lord, the reference number that is the common in the all the appointment letter, my lord. It is 13, 11, 12. So, my lord, the condition, my lord, that was imposed by the director at the time, my lord, some because of certain mistake, my lord, because there is some procedure, the circular style appointment letter was issued. So probably on that reason, my lord, that was not involved in my case, my lord, this condition has come. So by the affidavit, my lord, filed by the respondent number 2, where, my lord, the lordship, I will straight away not hesitating so much time, my lord. This they have admitted, my lord, whatever illegality is committed, my lord, in para number 10, in their affidavit, my lord, in page number 51, if it is not, my lord, again mistake, my lord.
Affidavit in opposition by respondent
number
number
2. Para number 10, my lord. Lordship got it?
Yes.
Yes. Lordship, my lord, get in para number 10. that in regard to the statement in paragraph number 10, 11 of the writ petition, the deponent beg to state that divide order number such and such issued by the Director of Higher Education Assam, the petitioner pay was already fixed notionally, my lord, at rupees 7,000 with effect from 1 with next date increment on 1/11/96 in the scale of pay rupees 5,725 to 11,826 per month. This is a scale, my lord, as per the available record. But after the receipt of the prayer petition dated 2019, which was forwarded by the principal, the governing body, Assam Higher Education Department, by later dated such and such, approved the fixation of pay as in respect of the petitioner, as my lord. This was the phase, my lord, fixation was how that was done. There is number 1 and number 2. Well, a D fixation, then number 3, the rupees 21,800 and as on 25/4/2008 with the DNI on 1/7/2009 in the pay status of rupees such and such with AGP such and such. It is also pertinent to mention here that the fixation of the mention in point number 1 and 2 was made on the basis of the state revised pay scale, my lord. So the whatever, my lord, pay scale was revised in 2007, well, that was not as per the, my lord, UGC pay scale. That was as per the, my lord, state scale. So as stated above, the annexure 4 of the writ petition, whereas the point number 3 pointed in UGC last, my lord, annexure point number 3, that is, my lord, UGC scale. So, my lord, after acquiring my MPhil degree, the, my lord, the UGC scale was only, my lord, accorded to me, not prior to that. Though, my lord, I am entitled from the date of initial appointment. From the 94, I am entitled for the UGC scale, but they have allotted the UGC scale from the date of when my MPhil was cleared, and I have submitted, that is from 1/4, my lord, 2008, 2008, my lord, not prior to that. Again, my lord, lordship.
So, you have completed your MPhil on 1st of April 2008.
8, my lord.
And since then, you have been granted
I
the
am,
UGC scale.
I am enjoying
And
the
your contention is that you are entitled to from the very date of
date
your
of
appointment.
appointment. But as the, there was no such condition that we implied that the candidate must obtain the NET or SLATE or any other things, and MPhil and PhD also. Only the qualification was the 55% marks in the master degree. With good quality, academic career, my lord. Again, my lord, lordship come to page number 54, my lord. My lord, they are elaborating, my lord, step by step. My lord, last paragraph, according to as per UGC regulation 1998, issued on 24/7/98, NET SLATE is a mandatory requirement for appointment of lecturer in colleges, but the UGC, my lord, they have, my lord, introduced the NET and SLATE in the 1991. But, my lord, the requirement of mandatory requirement, that is depend upon the state, my lord, when they are accepting this NET mandatory UGC qualification, eligibility qualification or not. So, in case of the Assam, the Government of Assam notification NET and SLATE as mandatory requirement eligibility criteria for the appointment of a lecturer in college throughout the state of Assam by its OM number sessions dated, my lord, 13/1/2000 only. So only date of the 13/1/2000, NET and SLATE is mandatory in case of the appointment of the lecturer, assistant professor in colleges, my lord. So not prior to that. So not prior to that means, my lord, prior to that, for sometimes that was when I am coming in my annexure also. Till 90, my lord, 87, my lord, 87 to 9, prior to 96, my appointment was, my lord, 94. There was a only qualification for appointment 55% in master degree, my lord. That I come. I have annexed the document, my lord, that is issued by the Director of Higher Education at the relevant time. Yes, ma'am. That is my annexure 11. At page 42.
Page number?
42, my lord. My writ petition.
42. Annexure 12.
Annexure 11, my lord.
Okay.
Here, my lord, till 1974, no qualification norms were prescribed by the UGC for teachers to be appointed in the degree colleges and aided colleges and to there's some mistake, my lord. This is erase some portion. Getting scale of pay prescribed by the state gov with minimum qualification of second class master degree. In 1973, the Government of Assam decided to allow you. My lord, there is a type copy, my lord, probably in lordship, my lord. In 1973, the Government of Assam decided to allow the UGC scale of pay to the teachers of the GIA college by the Government of Assam notification such since the my lord
GIA means?
Govt aided, my lord, gave Govt aided college, my lord, that should be GIA college. This notification such then again 73, since the benefit of the pay scale was accord to form 173 as normal relaxation was allowed to the teachers appointed prior to the cabinet decision dated 11/8/78. The debarred further appointment of the teachers having no UGC norms. The UGC has modified the norms times to time for appointment in the post of the lecturer in the colleges, which are as follows. My lord, here, lordship, the UGC, my lord, up to 18/8/78, my lord, no norms was there. Then, my lord, from 19/8/78 to 16/82, that was norms was the PU 50%, then degree honors on PARS course 50%, MA, MSc, MCOM 52.5%. Then, my lord, the norms was enhanced in 7/10/82 to 33/3/87, where, my lord, the MPhil PhD in second class MA, MCOM, MA, MSc, MCOM 52%, degree second class honors, and, my lord, the MA, MSc, MCOM second class, degree first class. Then, lordship will come to one straightway, my lord. This is, my lord, 1187, my lord. 1187. It is from, my lord, the last but one, my lord, this year mentioned below that, my lord, 1196 were there. 1187, 55% in master degree. Then in 1996, my lord, that has been enhanced. The minimum 55% mark in the post of graduate degree unreserved category, 12 class or net or slate, or the second clearance of net or slate, and minimum 50% marks in the post of postgraduate for SC, ST, clearance of net and slate. So, my lord, prior to 96, the qualification was only 55% mark. So, accordingly, my lord, the advertisement also, in pursuance of that advertisement, 3 posts were interviewed, and all 3 posts except me, the appointment was issued on the basis of their qualification, that is on 55 marks, without putting any harsh condition or any irrelevant condition which is not required at the relevant time. So, my lord, the government also admitted I have, my lord, in my reply, the annexed the notification. I have mentioned the notification, and they have also reiterated the same notification. Annexure 1 of my reply. This is, my lord, page.
No, you see, this last person,
Yes, madam.
1/1/1987, 50% in master degree.
Only 50% degree. Then 96, from 96 onwards, it comes
1/196, there's 50%, 55%, then
net and
slate.
slate. But one thing, my lord, though that was mentioned, that was not mandatorily followed by the state, my lord. State has followed by the notification. I have annexed, my lord, and they have also relied the same notification. That is annexure 1 of my reply. That notification came into existence on 13 January 2000, my lord. So, my lord, in the state of Assam, the net and slate were, my lord, compulsorily applicable, compulsorily applied in case of the appointment of the assistant professor in the colleges from 13 January 2000 only, not prior to that. Sometimes, my lord, the net and slate condition is imposed in respect of the some of the conditions of the appointment in case of the some appointment, and sometimes it is not mentioned in any appointment. So, there is some my lord, the uniformity application of the net and slate at the prior, my lord, 2000. So, 13 January 2000, net and slate has mandatory. Prior to that, not any such requirements are there. And so far, my appointment is concerned, I was appointed in 94. So prior to, my lord, 87 to till 87 to 96, prior to 96, the qualification was only 55. That is why, my lord, whenever the other persons where advertisement was in along with my post, Assamese and economics, well, they were appointed, no such condition was imposed. And that has been admitted by the government also, that the condition that net and slate is applicable in the state of Assam since 13 January 2000 only, not prior to that. So my case, my lord.
Okay, yes, is it the correct position?
No, Lordship.
Why?
Even in the 91 notification is also there, Lordship.
91.
Yes, Lordship. I'll have some.
91 is the UGC notification, my lord. This is not applicable in Assam.
When it is made applicable in case of Assam?
Application notification, they have relied, my lord. I have nothing to say.
Yes.
So far applicability of UGC notifications are concerned, UGC notifications are mandatory in nature. They need not be adopted by a particular state or by a particular university. And this has been upheld by the full bench of Kerala High Court also. Mandatory in nature. And I have filed my affidavit of on behalf of UGC. In the affidavit, I have enclosed the 1991 notification, where it clearly says that candidates besides the above qualification should have cleared eligibility test for lecturer conducted by UGC, CSIR, or similar test accredited by the UGC. So, test conducted by UGC means net, lordship.
Okay, all right.
And secondly, lordship, in the affidavit, I have also mentioned that this particular petitioner is getting the UGC pay scale only from 2008, 1st April 2008, after completion of MPhil. The petitioner has already accepted the job in the year 1994 on the ground that he will complete this MPhil within a period of 8 years. Now, Lordship, if we count 8 years from 1994, that is his date of appointment, it comes to 2002. He did not complete it within those 8 years. He completed it in 2008. That is after a delay of 6 years. In spite of that, he is being given UGC pay scale. I have pleaded in my affidavit stating that he is withdrawing UGC pay scale from 1st April 2008. Seems to be appropriate as per the conditions stated in Annex 3 of the writ petition.
But how the same benefit was given to the other teachers?
Lordship, negative
Equally.
quality is something which the court can never follow.
No, that may be. That may be. But once one benefit is given to similarly situated person, the same can be extended to the others also.
Negative equality cannot be claimed as a matter of right.
No, that is well settled proposition.
Yes, Lord. Negative equality cannot be claimed. It might.
Then no, first tell me, are you admitting in your affidavit that you have wrongly given the benefit to other candidates, other teachers? That's all right.
Giving benefit to any candidate or something.
He is a formal party, my lord.
In my right.
Is nothing to say on this my appointment.
No, the question is negative equality when you can take the plea.
Lordship,
Oh,
that.
Whenever you are admitting that you have wrongly given the benefit to some of the candidates.
Question that fell from your lordship, so I gave an answer. But that is not for me to justify
Hmm.
whether it is right or wrong, whatever they have done, because it's the state government who has done that. So they will have.
No,
to
that's all right. You are taking the plea of negative
actually.
equality.
Not negative equality. I am only taking one plea, two pleas, lordship. First plea is that UGC conducted examination or UGC accredited examination was a requirement right from 1991 and it is mandatory in nature. And my second plea is that since the UGC pay scale is being given after securing of MPhil, that is appropriate according to UGC. Because
Okay.
that condition was
Okay,
not.
yes, Mr. Upamanyu.
Lordship, there was a condition at the time.
How can you explain this? You have given some benefit to some of the candidates
Lordship,
and
just because
refused to give it to the petitioner?
Lordship, just because some financial benefits were given to some of the other persons, that doesn't mean, Lordship, he will get the same thing, Lordship. The point of negative equality comes, Lordship.
No, that's why I'm asking you whether you have admitted in your affidavit that you have wrongly given the benefit to others.
No, Lordship, not
Then-
admitted. No, Lordship, not given to others, but Lordship, he is not even entitled to get the UGC benefit. In 2008 also, he doesn't have the qualification, Lordship. He did his MPhil in the year 2008, Lordship.
No,
But the requisite qualification is
why
next
that
rate of
condition?
PhD.
No, you tell me.
And Lordship, he has accepted this condition in 1994. And he came before
Why
this
that
court.
condition was imposed in case of the petitioner, but not in case of other candidates?
Lordship, those conditions were imposed during those times, Lordship, because
No,
we are not having suitable candidates.
why the same was not applicable in case of other candidates?
He cannot claim that, Lordship, since it was not applicable to others. So he should also get the same benefit, Lordship. And that too, he has accepted this condition in the year 1994. And after almost 20 years in the year 2003, Lordship, he has filed this writ petition.
No, I have raised the complaint in 2019.
23.
19, I have raised the complaint.
Yes, but Lordship, he came before this court only in the year 2003.
not
Even if 19, Lordship, it is around 20 years, nearby 20 years, he came up with a writ that condition is there. But all along, he has accepted this condition, Lordship. There is delay in lectures on his part, Lordship. Lordship, may I submit?
Maybe whether the benefit he is entitled to can be denied on that count.
Yes, Lordship. First of all, he is not even qualified to get the UGC scale, Lordship, in the year 2008, Lordship.
Then what about this this Annexure 11? It is the notification of
They have also
your.
submitted the same notification, my lord. State how.
It is your notification.
I related their notification. They should speak from their own record.
Annexure 11, page number 42.
Yes, Lordship, but UGC from 91, Lordship, it is mandatory, Lordship. UGC qualification. Lordship,
Then
may I
how
have?
can you issue this notification?
Which?
The answer is not available with
No,
you.
Lordship, 42.
Your affidavit also.
2002, Lordship. this is
Yes.
2002, 13 lakh. But Lordship, without having the requisite qualification, he cannot claim the UGC benefits, Lordship. Lordship, may I be?
No,
permitted?
oh, then what is this? What is this notification?
This Lordship 2002 notification.
You see, on 1187,
Yes.
it was only 55% in master degree.
Yes.
And this net slate came into force with effect from 1196.
Lordship, I'll clarify this on Tuesday, Lordship.
No, my lord, this is
No,
a
no,
long pending cases, my lord. Several occasions, my lord, they
No,
took
no,
time to file the committee all evidence. Now
I
they
will
took
get
my
this
lord.
instruction, Lord.
And my lord, so far, my lord, their affidavit, you see, my lord, this is a mistaken affidavit. I have humbly submitted, my lord, with all respect. Because there in para 4, He is specifically now insisting that if from 91 that was applicable, but on the affidavit, they are saying that was practically applicable from 2006. And all the state in Assam, not only Assam, all over India, all the states, in different times, they have accepted the UGC mandate requirements and eligibility criteria. Not and the UGC has imposed one thing, even the pay scale also. If it is not they are giving the pay scale, but unless and until it is accepted by the state government, UGC scale cannot be claimed by any of the teachers. Until and unless it is accepted by the government state of Assam also. Same was happened. And whatever my learned friend is, my lord, he admitted the facts that in 2013 January 2000, this mandatory requirements of net and slate has come. So under what basis they are saying, and my lord, my one submission, my lord, the same question was raised by the Honorable Justice, my lord, you can add also. They brought in the record, there is no appointment during that period was, my lord, given without, my lord, the having the net and slate, my lord, or MPhil or PhD, my lord. Violating the condition of these requirements as per the guideline. This is issued by around 2002, where the required minimum qualification was a 55%. They failed to brought anything, and the affidavit was in that consonance, but that was not in that consonance, it was filed. No document they can show. Only in case of me, that condition has been imposed. All appointment during that period, all college lecturers were appointed without any net and slate. This is a simple qualification. And in my college, my lord, the other two persons were advertised in the same date, interviewed, my lord, also same date in a different boards. And in case of my appointment, they put that harsh condition, and others were, my lord, deprived, getting the all benefits. And now some of them retired. This one person is already retired from service. So why should I be deprived from this, getting this my benefit? What is my fault?
But only in the year 2003, Lordship, 2023, I challenged this condition, Lordship. So, Lordship, he is.
Well, my lord, 2019, whenever my pay scale was fixed in a different way, even as because there is some, my lord, discrepancy by prior to fixing of my scale at the time of the safe scale. So, safe scale, whenever that is converted to the UGC scale, there is some defect. So, whenever the 7th pay commission was imposed, at that time when my scale was, my lord, again revised, there is some defect. So on that matter, I brought these things to the notice of the department concerned to rectify these things by filing an application in 2019. And since they also I am objecting these things, same thing. But that was not considered. They now cannot say that I have come in later stage, so continuing the illegality, and I will be deprived from my eligibility right, whatever I am entitled, along with my co-colleagues. How they can say? And state they can come with that stand that yes, he is not at that time, in spite of contrary their own record. This is own record.
Mr. Mohanta, let him obtain instruction on Monday.
Applied for leave the entire next week. I'm not available.
Your party,
Formal party, my lord, nothing to say.
Only he will obtain instruction. Your part is completed.
In that case, my junior will be available.
Tuesday. On the any difficulties on Tuesday?
Wednesday. 18th, Lord, Wednesday.
Wednesday. Wednesday. Okay. Art Mr. Pimonto, learn it for the Mr. Please learn it. Sending counsel for the respondent in higher duties of department. And Dr. Agarwal, learn it. Sending counsel for the respondent number 3, UGC. Art in part is the matter Wednesday. So as to enable Mr. Upamunyo to obtain inspection in respect of Annexer 11,
page 42.
Page 40.
Must.
Item 11.
Please, your lordship.
Yes.
Lordship, in this case, Lordship, applicant number 4 has been died, Lordship. So, Lordship, 2 weeks time may be granted.
Respondent number 4 died.
Applicant number 4, Lordship.
Applicant number 4. Applicant or appellant?
Appellant. Appellant, sorry,
Appellant.
Lordship.
Appellant number 4, Dinesh Ghosh.
Dinesh Ghosh.
Heard Mr.
M. Hussain.
M. Hussain, learned counsel for the appellant, and Mr.
H. Buragovind.
H. Buragovind, learned counsel for the all the respondents. For all the respondents. The learned counsel for the appellant submits that appellant number 4, Dinesh Ghosh, suffered demise. And as such, there is a requirement for completing the legal heirs of the said appellant as party in this appeal, and he prays for granting him 2 weeks time.
2 weeks.
2 weeks time. Here is accordingly allowed. This is a legal matter after 2 weeks. Okay. 24.
Much.
Obliged.
May I please, Your Lordship? Lordship, on 27/5/2025, we have informed the Honorable Court about the date of petitioner number 4. And accordingly, we were directed to file substitution for impleting the legal heirs. Lordship, within 4 weeks, and Lordship, yesterday we have filed 3 IAs connecting to the substitution.
Okay. Heard Mr.
Lordship, the record of the IAs are not tagged here.
That's all right. What is your name?
Lordship, W. Hawk.
W. Hawk,
On
learned
behalf of
counsel,
Mr. S.
petitioner, and Mr. Guhai for respondent.
All the respondents, sir.
For all the respondents. The learned counsel for the petitioner submits that he has already filed 3 interlocutory application for substitution,
Condonation and abatement.
substitution, condonation, and for abatement. And the same were not listed before the court. Accordingly, it is provided that registrar shall list this petition along with the 3 interlocutory application filed by the petitioner on 19th.
Obliged.
Obliged, Lordship.
14 to 16. 14 to 16.
May I lord?
Yeah.
Your Lordship, my lord, item number 14 is for the collection of the terminal charge and graded concession, and 15 also for terminal charges. These 2 cases is covered by the decision of the lordship, already passed in MFA 26 of 2016, my lord. So, my lord, in the meantime, respondents filed a review petition challenging this order passed in MFA number 27 of 2016 by way of filing review petition, my lord. So, item number 16 is the review petition, my lord. So I have been instructed to appear in this case in review petition since I have conducted this case, yes, my lord. So I filed Wakalatnama. I have not received the copy of the review petition.
So all these 3 matters are ready for hearing.
Yes, ma'am. This is the common matter, matter, the identical matter is covered by the decision of this lordship by the order judgment dated 10th February 2025, passed in MFA 27 of 2016. This same matter, collection of the terminal charge and graded concession. The lordships allowed that in favor of the collection of the terminal charge in favor of the railway, my lord. And for graded concession, this remanded back this matter to the RCT for fresh decision, my lord. This is the judgment, my lord.
In item number 16.
My lord?
Item number 16.
Yes, 16, my lord. 16 is, this 14, 15 is covered by decision of the item number 16. 16 means they have filed review petition in item number 16 against this judgment, my lord.
Okay. What is the ground?
This is the, my lord, already, lordship already clearly explained, along with the various circulars of the railway regarding collection of the terminal charge and decision of the honorable court in MFA number 100 of 2010,
No,
my
no.
lord.
Review petition is prepared by them.
Them, my lord.
They will argue.
No, I am not arguing for the review petition because I have not received the copy of the review petition.
Oh, you have not received.
I have not received, only I have been instructed from by the Western Railway.
So according to you, this judgment will cover the other two petition,
Yes,
other
my
two
lord.
appeal.
Unless the review petition is
Review.
reviewed, then my lord, this matter will be heard that later on, my lord.
Okay. So
May
madam,
I
you
please,
furnish on a review
Lordship,
petition?
My submission would be, Lordship, in item number 14 and 15. The judgment which was delivered in item number 16 is not covered with these two items, Lordship. My submission would be that, Lordship. Because here, Lordship has delivered the judgment based on the decision passed by the Honorable Justice, former Honorable Justice Rumi Kumari Kokon in MFA number 100 of 2011. And that judgment was not relevant to the item number 14 and 15 because at that point,
Okay, we'll say, we'll hear you.
let it,
First, let her furnish a copy of
Yes,
this
Lordship.
review petition.
I will furnish a copy. It
We'll,
is number 16.
yes,
Yes.
we'll hear all the matters together there.
Yes, my lord.
Huh?
Yes. So
Uh,
petition may be directed to, the review petition may be directed to file, serve the copy to me, my.
Yes,
I will
it
furnish.
is available with you.
Right now, it's not available. I will furnish it.
When?
Within tomorrow, Lordship, by tomorrow.
By tomorrow?
Yes.
Okay. Third miss, use of property,
Yes, sir.
learned
Special senior election.
special senior railway council. In item number 14, 15. And in 16 says for response. And madam, your good name, please?
Sharma.
M. Sharma.
Yes, sir. For all the respondents.
M. Sharma for
Item number 14 and
item
15.
number 16 for the petitioner
Yes,
and 14 and 15 for the respondent.
respondent.
Miss Chakraborty, learned counsel for the respondent number 1 submits that she has not been furnished with a copy of the review petition number 63 of 2025. Ms. M. Sharma, learned counsel for the petitioner, submits that she will furnish a copy of the review petition to Ms. Chakraborty by tomorrow.
Yes, sir.
By tomorrow. And having heard the submission of both the parties, learned counsel for both the parties, it is provided that recessal list item number 14, 15, and 16 together on picture.
Let it be after vacation, Lord.
Okay, okay.
After vacation, my lord.
After vacation.
17 July.
17th July.
Okay.
Okay.
Item 17.
May I please, your lordship. Lordship, in this matter, my lord, my senior Mr. B. Banerjee appeared, my lord. And after his death, my lord, the file is lying with his chamber, my lord. And in the lockdown period, my lord, all the files has been demolished by the termite, my lord. That is why termite. That is why I informed the parties, my lord, and it is required 6 weeks time, my lord. This is the file. It is 4 weeks time may be granted, my lord, to obtain necessary records, my lord, from the LCR, my lord.
Okay. On the pair being made by Mr.
A. Mubarak, my lord. My name
A.
is also
Mubarak,
here, my lord.
learned counsel appearing on behalf of Mr. Banerjee,
Lordship.
learned counsel for the appellant, having not been objected by Mr. Mr. Sheikh. Any objection? Not been objected by Mr. M.S. Sheikh, learned counsel for the respondent. Recessal list the matter after vacation.
After vacation, after 4
vacation.
weeks. Another aspect, my lord, in this matter, my lord,
The appellant number 1, my lord. Who is substituted on the death of appellant number 1, my lord, was died, my lord, on 5/7/23, my lord.
Okay, you.
Already
File an application.
Already substituted, but her name may be struck up, my lord.
Name will remain, my lord. The substitution parties will there.
Substitution here, my lord.
Substitution is there, no problem.
Okay, next that we will consider it
After vacation, my lord.
after vacation. We have not fixed a date, but the registry will fix the date.
My lord.
Item 19.
My lord, in this matter, my lord, I want, my lord, only 2-3 days accommodation, my lord. In this matter, my lord, and the appellant, my lord. Here is the substantial question of law is whether the finding of the both courts below, the registered sale deed, exhibit 5 was null and void. The petition appellant herein is, my lord, is a purchaser of a plot of land, my lord. And the respondent claimed that, my lord, he is a tenant. So the question of law is framed that after determining the plaintiff as a tenant, whether the sale deed can be declared null and void. So 2 or 3 days on this point, my lord, I have to clarify some to clear, my lord. On next Thursday, my lord.
Okay, on the prayer being made by Mr. M.J. Kadir, learned counsel for the appellant, having not been objected by Ms. B. Hazurika, learned counsel for the respondent, raises and lays the matter on.
15 to that.
After vacation.
Public.
Item 20.
May it please your lordship. Lordship, my learned senior friend has made a calculation and I'm willing to concede.
Made a
calculation.
My lord, this appeal, they have filed an appeal, MSCT appeal, my lord, against the award, my lord. But in the calculation, my lord, there was a mistake in the appeal. Because he was below 23, his age of 23, the multiplier would be 80. They have calculated in 70. And in that respect, my lord, opposition. So we have calculated and we have submitted the report to your lordship that this would be the award money. For a, we have for enhancement.
Your
Now,
lordship,
what is your submission?
your lordship, only one thing I want to submit, that the future prospect won't bear any interest. Otherwise, the appeal is going against us. And I think the claimants are entitled to this amount. Because multiplier, it was 17, which was granted before the tribunal. So it will be increased to 18. And
as per this Sarla
Sarla case. And future prospect was given 50% in the tribunal stage. And here my learned friend has taken 40% future.
I have given the calculation, my lord. That
Your lordship, that second row, 11,43,504, that amount won't bear any interest. That is my submission.
the
Interest.
Yes.
interest will bear on the total amount. Not
Future
per-
prospect.
No, future prospect is 40%, that is there. The interest is always on the total amount.
No,
From
no,
the
there is
date
a
of-
decision of Supreme Court.
The 40, future prospect 40%.
No, no, in
According to
respect
the
of
age.
interest on future prospect.
Well, that-
Yet that decision of Supreme Court is available with you.
Your lordship, right now, I'm not having.
You produce it on Tuesday then.
Okay, your lordship.
We'll keep the matter as part.
Okay.
Third, Mr. S. Dotto, learned counsel for the appellant, and Mr. Bhattacharjee, learned counsel for the respondent. Third in part, lays the matter on Tuesday.
On
Tuesday.
So as to enable Mr. Dotto to produce before this court the decision of Honorable Supreme Court in respect of imposing interest upon future prospect.
Much of
Lordship, I appeal for respondent number 7.
7, okay. Miss, your good name? ABRA, learned counsel for the respondent number 7, and you for? 5 and 6, your name? A?
40% state. Total amount of interest on it.
22.
Lordship, RSA matter today, it can be possible, Lordship. Next,
Not possible.
next week, Lordship.
How much time you will take?
I will take some time, Lordship.
Some time. This is the 2019 matter, alright.
Next week.
Malik?
Lordship. Lordship, may kindly fix date, my lord. If my learned friend is difficult.
আজি নহব না এটা second
Can we fix it after vacation? Because already we have fixed several matters.
after vacation is better, Lordship.
Okay. As agreed by learned advocate of both the parties, raise the matter on. We will fix it at
Yes, Lordship.
22nd July.
22nd July.
Obliges.
Oblige.
Because it will take time, otherwise Lordship will wastage of time. And I cannot finish the matter, ultimately case will be pardoned and delayed. That is why Lordship I am praying.
23rd. 23.
Okay, sir. It's short matter, Lordship. Basically, this is a case under the Employees Compensation Act. Case is
Workmen.
Workmen Compensation Act. Lordship, regarding in this particular case, matter in dispute is like this, Lordship. The driver was not traceable. The owner has filed an affair stating that his vehicle has been taken away by the driver and it has been, he has misappropriated the vehicle. Ultimately, police has registered a section 406,
Hmm.
criminal breach of trust. And police has submitted final report.
Hmm.
Lordship will find judgment at page 5. Claim has been filed after 11 years from the date of alleged lost.
Hmm.
And Honorable Supreme Court has categorically held in a decision against the judgment passed by this Honorable Court. Supreme Court has categorically given a finding that to get a presumption that regarding death of a person, the Employees Compensation Commissioner of Employees Compensation Act is not competent to decide a matter regarding death of a person on the basis of a presumption under section 107 of the Evidence Act.
Hmm.
Regarding death of a person within 7 years, there is a presumption regarding death of a person who is not traceable for last 7 years.
Hmm.
That presumption cannot be taken by the Supreme Court. And before by the Lordship, the Employees Compensation Act.
Hmm.
Lordship will find the judgment reported in 2008 for SCC 572.
Hmm.
That is also
Relevant paragraph.
2008 for SCC 572.
Relevant paragraph.
Lordship will find from more para 16 onwards, Lordship.
Okay.
The sine qua non for invoking the provision of appended in section 147 is that employee must be engaged in driving of the vehicle. Death or bodily injury must occur arising out in course of employment. The 1923 Act of 1988, therefore, would be applicable only if the condition precedent laid down thereunder are satisfied. The employer lost first information report against Bipul Gogoi. This charge sheet was also filed. There is nothing on record to show that death occurred of Bipul Gogoi in an accident arising out of in course of employment. If some miscreants have taken away the driver along with the vehicle or has murdered him, is an offense. It accepts that certain situation does not give rise to a presumption that the death had occurred arising out of in course of employment. Some evidence should have been adduced in this behalf if the person brought on record by the police was correct, namely he had himself run away with the vehicle and had not been heard for a period of 7 years, particularly who had been declared proclaimed offender by a court of law presumption under section 108 of the Evidence Act could not have been invoked by criminal court by dropping the criminal case that he is dead. In our opinion, in case of this nature, this said provision could not have been invoked for the purpose of grant of compensation under 1923 Act without any other evidence having been brought on records. Section 108 and 109 of the Evidence Act are founded on the presumption that things once proved to have been existed in a particular state are to be understood in continuing in that state until contrary is established by evidence, either direct or circumstantial. Said provision can be invoked in a legally proceeding by date of a person may be in issue. Section does not say that the presumption would be applicable in all situations. It shall not be applied in respect of a person who, as he in that situation, may not be communicated with his relations. Furthermore, in a case of this nature, it is also difficult to rely upon the self-serving statement made by the claimant that they had not heard their son for a period of 7 years. Commissioner of Workmen Compensation or High Court did not assign a reason as to why the fact disclosed in the charge sheet, which was filed before the Commissioner, Bipul Gogoi himself ran away with the vehicle, would not be a relevant fact, particularly when cognizance had been taken by competent court of law on the basis of the situation. Section 3 of 1923 Act would be attracted only when the condition precedent thereof are fulfilled, not otherwise. View which have been taken for the support of the judgment of this court, to come to come within the Act, the injury by accident must be arise both out and in course of employment. The word in course of employment means in course of the work which the workman is employed to do and which is incidental to it. The word arising out of employment are understood to mean that during the course of employment, injury has resulted some risks or incidental to the duties of the service, which unless engaged in the duty owing to the master, it is reasonable to believe that workman would not otherwise have suffered. In other words, there must be a causal relationship between the accident and employment. The expression arising out of employment is again not confined to the man's mere cause of employment. The expression applies to the employment as such of its nature, its condition, its obligation, and incidence it by reasons of any those factors of a brought within the zone of special danger. The injury would be one which arises out of employment. Para 21 reference under section 3(1), it has to be established that there was some causal connection between the death of a workman and his employment. If the workman dies as a natural result of the disease which he was suffering while suffering from a particular disease, or he dies that disease as a result of wear and tear of the employment, no liability would be fixed on the employer. But if the employment is contributory cause of the accelerated to the death, or if the death was due to not only for disease but also disease coupled with the employment, then it can be said that the death arose out of the employment and employer would be liable. The expression accident means untoward mishap which is not expected or designed. Injury means physical injury. Expression accident is used in a popular and ordinary sense, the word or denoting and work on look for a mishap or untoward events which is not expected or designed. The above view of Lord Iman, I think that the context shows that they're using the word designated by Lord Iman referring to. Furthermore, the right of the parties were required to be determined as on date of the incident, namely on 9/10/1996. It is therefore difficult to hold that a subsequent event that too, by raising a presumption in terms of section 108 of the evidence, can give rise to a prosecution of claim, same and except in a very exceptional cases. Thus, in the relevant date of the for determination of date of compensation is that of accident, not on the date of execution of claim. For the reason the above mentioned, impugned judgment cannot be sustained, is set aside accordingly, the appeal is allowed. However, nobody has to appear on behalf of the respondent. So in this particular case also, Lordship, I will take your Lordship to the case in hand. Lordship will find. Present claim has been filed. Page 6. Page 5. Case arose out
Judgment.
Judgment, page
Yeah.
5.
Yes.
Case arose out of an application under section 20 of the Employees Compensation Act 1923 by one Hasina Begum, wife of late Inus Ali, mother of the deceased Nurul Haq of village Karoda, under Baheta Police Station in the district of Kamrup, Guwahati, Assam for compensation under the Employees Compensation Act on account of civil death presumed after 7 years of missing her son Nurul Haq since 15/10/2005. The fact of the case is that petitioner's son Nurul Haq was employed owned by OP1 Mrs. Deepsika Das, Aman vehicle. While Nurul Haq was driving his said vehicle loaded with passenger and he along with the vehicle went missing. The owner of the vehicle was searching for the vehicle in different places for 4 to 5 days, finding no clue. Lost affair on 20/12/2005 at Bhordomukh Police Station in the district of Kamrup, Assam. The owner of the vehicle informed the matter to the branch manager Oriental Insurance Company with the Maligaon branch, filed later with a demand Bhordomukh, filed registered under section 406 IPC. Being Bhordomukh Police Station case number Iman, and investigated matter in possible manner but failed to trace out the vehicle as well as the driver. Thereafter submitted final report before the Chief Judicial Magistrate Kamrup, Guwahati, FR number Iman, which was accepted by the SDGM 1. I ordered the treatment since the dead body of Nurul Haq could not be recovered. Claimant had to wait for the charge sheet and final report the police. Police filed FIR to Chief Judicial Magistrate Kamrup, which was subsequently accepted by the concerned magistrate on 27/1/09, confirming that the claimant's son Nurul Haq was not alive, but the claimant was told that civil death could be presumed only after 7 years of his absence. After having coupled with the court's order, claimant filed this case before Commissioner Employees Compensation at Guwahati on account of civil death of the person. Claimant stated that her son was 21 years age at the time of accident. He was receiving 7,000 rupees salary per month, and in addition 50 rupees as food allowance. Claimant stated OP1 owner of the vehicle was aware of the incident but failed to comply with the provision of Employees Compensation Act. Claimant disclosed that a vehicle in question was duly insured to OP2 Oriental Insurance Company Limited, and policy insurance was valid at the time of accident. Claimant praised for grant of compensation of 7 lakhs. On receipt of the claim petition case registered, notice were sent to the opposite parties for appearance and filing written statement and objection, if any, hereof. OP1 Deepsika, owner of the vehicle, filed written statement admitting the inter alia that Nurul Haq was the driver of his Bolero vehicle. While driving said vehicle with passenger went missing along with the vehicle in spite of searching of the vehicle at various places for 4 or 5 days. Vehicle along with the driver Nurul Haq could not be traced out. Accordingly, FIR was lodged at Bhordomukh Police Station. Oriental Insurance Company was also informed about the matter. In this connection, Bhordomukh Police registered a case under section 406 IPC, which is numbered as BP case number 70/06, investigated the matter in all possible manner. Investigating officer, having failed to trace out the missing vehicle along with the driver, submitted a final report.
Okay, sir.
So ultimately, Lordship will find the FIR. FIR has been filed by the owner that vehicle has been taken away by the driver along with him, and he was not traceable. So police has registered a case under section 406 IPC.
Thereafter submitted final report.
Final report that on traceable will open the case. So ultimately, there's a presumption case has been, besides this, Lordship will find, according to him, Nurul Haq not traceable since 2015/12/2005. In the initial page 5, Lordship. Nurul Haq was not traceable according to him on 15/12/2005. From the judgment, page 5, Lordship. 15/20/2005. Now, if presumption is also drawn within 7 years, then it is within 2012. Case should be filed within 2012. Presumption within 7 years. This case has been filed in 2016.
And when the final report was submitted by police?
Final report was submitted by the police.
97.
Police has submitted final report on 31/3/2008. 31/3/2008. Final report number 23/08.
2008.
2008.
So is it their case that they awaited till filing of the final report by police?
According to them, police have ultimately after submission of the final report, they have filed this MSA. If WC, if case has been filed after filing of the final report and acceptance by the CGM, then limitation for filing a WC claim is 2 years.
Were there any substantial question of law is framed here?
Lordship.
What are the?
It was framed on 3/1/2020.
So this is one of your play that it was not filed within the period of limitation.
Section 10 has specifically stated it should be filed within 2 years from the date of date.
Section?
Section 10 of Workmen Compensation Act 1923. P1/2020. नहीं रखा है.
So is there any scope for condonation of the delay?
No.
No.
No application.
No. Is there any provision in the act?
No, Lordship, Employees Compensation Act did not provide any application for condonation of delay.
Then we have to go to the limitation act. What limitation act says?
Section 10 specifically stated within 2 years from the date of.
No, this
date.
is all right. Whether section 5 of the limitation act will be applicable here regarding condonation. And there was no application. Whether in the claim petition they have offered any explanation? No, nothing.
Lordship can see the record.
Okay.
Limitation info. Give me a sec. Presumption. Secondly, there is another judgment of the Supreme Court. I have the one copy. I will give the hand over the copy, Lordship.
There is some explanation in paragraph number 4.
In prayer portion also there is lordship, prayer for condoning the delay. In the prayer portion also there is a prayer. It is therefore prayed that your honor may be pleased to admit this application after condoning the delay in filing of the instant claim petition and pass an award. Lordship, prayer is also.
Whether any order was passed at the time of admission of this petition by the workman compensation?
Lordship, I can see the LCR, Lordship.
There is no such order. It simply admitted the petition, then issued notice to the parties.
However, in the judgment there is there lordship, condonation of delay is there in the judgment law. The
Which
judgment
page?
law.
Page 9.
Page 9, para,
Last one or paragraph.
yes, lordship. Last paragraph. Okay. Paragraph, the next argument or that the claim petition. Just the paragraph before the last paragraph. Lord.
Yes.
The next argument that the claim petition has not been filed within 2 years of the occurrence of the accident, and as much as the petition and as such the petition is liable to be dismissed, is not tenable in this particular case, in as much the claimant's son is presumed to be dead after 12 years from the date of his missing. The petitioner's son Nurul Haq Ali, driver of vehicle number Iman, went missing on 15/1/2005. It should be 2008, 15/12, lordship. There's a typographical mistake here. The Verlok police station police personnel submitted the final report to the Chief Judicial Magistrate Kamrup Metro on 27/1/2009, who confirmed that Nurul Haq was not alive, but the civil death of Nurul Haq Ali can be presumed after 7 years of his absence. Calculated on the basis of this procedure, the claim petition is found to have been filed within the limitation period. That is
Lordship,
the-
presumption is 7 years. 108 of the Evidence Act, burden of proving the person who is alive or not or hurt for 7 years. Provided that when they question whether a man is alive or dead, it is proved that he has not been hurt for 7 years. For those who would necessarily been hurt him and he had alive, burden of proving that he is alive is shifted the person who affirms it. 7 years.
Yes, sir.
And Supreme Court another judgment has categorically stated, Lordship, 2005 8 SEC 330 regarding presumption from para 22, relevant portion is at what point of time the person was dead is not a matter of presumption but evidence. Factual and circumstances and the onus of proving that he is dead had taken place at any given point of time. Death since the disappearance is within the period of 7 years, lies on the person who seeks the claim.
Which judgment you are reading?
This is Lordship 2005 8 SEC 330.
Could you furnish a copy to me?
Lordship, I'm giving you. And as per FIR, Lordship, India FIR is on record. According to FIR, সন্মানপূৰ্বক নিবেদন এই যে মই বৰ্তমান ঘৰ হেঙেৰাবাৰীত যোৱা ইংৰাজী 15-12 তাৰিখে ৰাতিপুৱা মোৰ ড্ৰাইভাৰ মনুল হক নামৰ ড্ৰাইভাৰজনে হৰলুপ থানাৰ পৰা ওচৰৰ অন্তৰ্গত শান্তিপুৰৰ পৰা ভাড়া মাৰাৰ উদ্দেশ্য তলত নম্বৰ গাড়ীখন লৈ আহে যদিও উক্ত গাড়ীখনৰ পৰা ড্ৰাইভাৰজনে গাড়ীখন লৈ ঘূৰি অহা নাই আৰু কোনো ধৰণৰ খা খবৰ বা ফোন আদিও কৰা নাই। আমি বহু ধৰণৰ অনুসন্ধান কৰি যদিও বৰ্তমানলৈ কোনো সূত্ৰ পোৱা নাই। গতিকে মহোদয় প্ৰাৰ্থনা জানো যাতে বৰ্তমান ঘটনা ড্ৰাইভাৰ আৰু গাড়ীৰ সন্ধান উলিয়াই দিয়ে যেন। On this basis, Lordship, the case has been registered under section 40, criminal breach of trust. And specific statement is মোৰ ড্ৰাইভাৰ গাড়ীখন সোঁসত্ৰ পোৱা নাই এতিয়া মোৰ ড্ৰাইভাৰ নুৰুল হকৰ ওপৰত সন্দেহ হয় এই গাড়ীখন নি বিক্ৰী কৰি পলাই গৈছে
No, that could not be substantiated because police has returned the case in final report.
Final report stating that what has been stated in the final report regarding not regarding death of the person Police has submitted final report. গাড়ীখন বিক্ৰী কৰি তেওঁ ক'ৰবাত আত্মগোপন কৰি আছে। গাড়ীখন বিক্ৰী কৰি তেওঁ ক'ৰবাত আত্মগোপন কৰি আছে। গতিকে পদকীয়াক সঠিক ঠিকনা বাহিৰ কৰি গোচৰীয়া বা গাড়ীখন উদ্ধাৰ কৰাৰ বাবে যত্নৱান হৈ পৰিছে। According to police report, police has not stated that he was killed. Police has stated that he has sold a vehicle and he আত্মগোপন কৰি আছে।
So whether that is based on any materials?
That has been accepted by the CGM.
No. CGM has accepted the final report. That is a different aspect. But the question is whether the finding recorded by the investigating officer is based on any material.
On the basis of 161 statement recorded by the police at the time of investigation, that they cannot trace out the vehicle. And that is why Lordship, this statement has been recorded of the local people. And thereafter give a report that গাড়ীখন বিক্ৰী কৰি তেওঁ ক'ৰবাত আত্মগোপন কৰি আছে। গতিকে পদকীয়া সঠিক বিকাশ বাহিৰ কৰি গোচৰীয়াৰ বলেৰো গাড়ীখন উদ্ধাৰ কৰিবৰ কাৰণে যত্নৱান আছো। পদকীয়া বলেৰো গাড়ীখন উদ্ধাৰ হোৱাৰ আশা ক্ষীণ। ভৱিষ্যতলৈও গতিকে গাড়ীখনৰ সংসূত্ৰ পালে গতিকে উপৰোক্ত ভাৰতীয় দণ্ডবিধিৰ 406 ধাৰাত সত্য কিন্তু সংসূত্ৰবিহীন বুলি মান্য কৰি আদালতত এই চূড়ান্ত প্ৰতিবেদন দাখিল কৰিম।
No, the ground is different, not stated by you. The ground is that they have found no clue.
They have stated যে গাড়ীখনৰ কোনো সংসূত্ৰ পোৱা নাই।
Yes, no clue.
They have stated that the driver has sold the vehicle to some person and thereafter he পলাই আছে, আত্মগোপন কৰি আছে।
No, that is the statement of the witnesses, but
No, that is the final report.
The final report is filed on the basis of no clue.
গাড়ীখনৰ
Court has accepted it. Court has accepted. Whether that final report is copy of the is part of the
record আছে।
It is on the record.
It has been exhibited along with the claim petition.
Pardon?
It has been exhibited along with the claim petition. It's like the police is telling the informant to find out the vehicle for himself. They have stated that they have no clue where the vehicle is.
See, in the final report, it is stated that
তদন্তকালত দেখা যায় যে
না গতিকে উপৰোক্ত কাৰণবোৰৰ পৰিপ্ৰেক্ষিতত গোচৰটো অযথা পেলাই নথৈ ভাৰতীয় দণ্ডবিধি আইনৰ 406 ধাৰাত সত্য কিন্তু সংসূত্ৰবিহীন বুলি মান্যবৰ আদালতলৈ এই চূড়ান্ত প্ৰতিবেদন দাখিল কৰিলো।
That means 406.
Yes.
There is no presumption that he was killed by some person.
No, there was no presumption, but the court has drawn the presumption.
Court
Yes, Commissioner.
Commissioner.
Yes.
Whether commissioner can take a presumption regarding
Yes,
date of
that is
person,
the
it is civil
question.
court only.
That is the question.
That is a civil court only. Declaration of a person to be dead, that presumption can be drawn by a civil court only. Employees Compensation Commissioner has no power to get a presumption. And there is a decision to this effect. That presumption can be drawn, declaration should be filed, and there should be presumption by competent civil court regarding death of a person. Employees Compensation Act did not provide to take a presumption.
Where is that proposition?
Lordship, regarding the presumption.
Yes.
Lordship, I have the judgment today. I have not brought it.
Can you produce it on next
Lordship.
day?
If Lordship fixes another date, I will produce the judgment. Pardon, Lordship can pardon.
Okay, you take these two judgments referred by him.
Okay.
You see whether it is applicable in your case or not. You apprise this court on next day.
Yes, sir.
Heard Mr. Goswami, learned counsel for the appellant. Then Mr.
K. Das, Lord.
K. Das, learned counsel for the respondent. Heard in part. List the matter on
22nd July.
2nd of July.
Apply this.
As part heard.
Item 26.
May I please, your lordship? Lordship,
Lordship, may it please, your lordship, with the consent of the other party, I beg to, with the consent of the other party, I beg to, beg to pray to adjourn this matter for today.
Okay, as agreed by learned advocate to both the parties, recess shall list the matter after vacation.
After vacation.
month of, because it deals with the pension, your lordship had admitted this, it deals, if, because I don't think it will be before vacation, I don't think there will be,
Okay, after vacation.
after, a date may be kindly be fixed.
Okay.
24th July.
Highly obliged.
Item 30, part matter.
My lord, here, my lord. On last occasion, I have taken time to file my written argument.
File?
To file written argument, man. I'll not
Yes.
file, man.
You have prepared your argument.
No, man, I don't want to file my written argument. I'll
So you are not
orally
willing
argue.
to file a written argument.
My lord, I will orally argue, man.
But today time is also COVID. On Tuesday, then at 2 p.m.
On Thursday, my lord. On 19th Thursday.
19.
Okay.
As agreed by learned advocates of both the parties, this is the matter on Thursday at 2 p.m.
At 2 p.m.
Bless you.
Deeply obliged.